Sitting my lord.
That has not come today.
Not come. Can it come tomorrow?
Why it has not come? When memos are
Probably memo was given probably some.
why come?
I put it.
Why lawyer should move memo then?
Yes.
Get it.
Today.
Yeah, today get it. If when this says the matter should be posted, it should be posted. But this matter is not posted. Just hold enquiry. Ask why it is not posted. For this matter.
After lunch?
After lunch. All right.
But this matter was the last
Can it be
this matter was in the list.
with apology? Can it be taken up tomorrow? I'll call this matter tomorrow. Hold enquiry. Whenever judge says memo is taken, matter has to come with whatever stage. It has to come before the court.
But this matter was in the list. The last week notice could not reach. And also thereafter also filed memo.
Which year?
That is 2024. The matter in the list. Matter in the list.
But it will come to everybody. It will come to more action.
But it's a case of regulation measures. This honorable court was pleased to issue notice measures. The status quo. In the meantime, what the opposite parties have done measures, issuing advertisement in the same proceeding which the petitioner continues. I file in IE.
Next. Which year? 23. Okay. 2 weeks. We'll have it up to 2 weeks. Which year? Once they're moving. Right now, how we will know? Which right now that 2 weeks, 1 week. लिखना उसको मेमो के ऊपर ना. How will you know? Now just you are collecting the memos. How will you know which date they should be posted? 23 matter, 2 matters they have moved. 2 weeks. 2 weeks. 23 matters, 2 weeks.
24 RSFC.
First time admission, whichever first time admissions.
I give first time admission.
Give that. First time next. First time admissions.
Tomorrow.
Day after tomorrow, next week.
My lord, my matter is specifically adjourned to week commencing 30th June 2025, my lord.
Huh?
Week commencing 30th June 2025, my lord. That is not listed.
Give that.
This is the forward matter, 2024 matter, my lord. RSFC.
Yeah, take it 2 weeks.
2025 matter. After notice matter, your lordship, actually a post joint inquiry was initiated, and
They have to write down, na? Give that.
2025 matter, your lordship. Give after notice matter.
2 weeks.
Regulation of service matter.
2 weeks.
Is it from matter?
What we told.
Regulation of service matter.
Is it? Is it from
Service to 25.
is it from matter? Will lordship directed to listed on 8 mile till to not listed mile.
Not listed.
Mile.
Next Thursday.
Oblige lordships.
Thursday.
Tomorrow. Regulation of service matter, 2025 matter.
25 matter.
My lord.
First time it is.
No, my lord. This one
This has happened.
My lord.
3 weeks.
Pardon to make a mention, my lord. 24 matter, my lord. Readings are complete. Your salary, my lord.
24 matter.
Yes, sir.
Readings are complete, my lord. Second week of October.
My lord, it is a matter appointment under the Rehabilitation Assistance Scheme, my lord. Petitioner is a widow. It is a matter of 2024 month.
24?
Yes, my lord.
All right. 4 weeks. Take it.
Okay.
Admission matter 24.
Admission matter.
Notice already.
Stage they are coming.
No, my notice already issued.
Is it coming for the first time or notice is issued?
Notice issued.
Issued. All right. In first week, second week of October. Take that. October second week. All the 3.
मैं पर्सन हूँ ये 8 तारीख की लिस्टिंग हुआ था लेकिन रीच नहीं किया ये कोई हाई स्कूल टीचर मैटर है कॉन्ट्रेक्चुअल सर्विस का
हाई स्कूल टीचर मांगनी क्या है उसमें प्रेयर क्या है
प्रेयर है अपॉइंटमेंट के लिए
अपॉइंटमेंट
इन वैकेंट पोस्ट रिमेनिंग वैकेंट पोस्ट सिमिलर में बहुत सारे को दिया गया है
आप कहाँ से आ रहे हैं
हम खोर्धा से आ रहे हैं
खोर्धा कितना किलोमीटर
80 किलोमीटर
80 किलोमीटर कब चाहिए आपको
14 सर
14 थोड़ा तकलीफ है वो 20th को लेंगे, ठीक है? 20th
सर आपण बॉलम बोलतो मॅडम सर जे यापैकी पाणी ॲडव्होकेट 6 item 44
one second, sir. Yes, sir.
44 sir.
Item 18.
Item 18, my lord.
Yes, sir. Last matter, singular matter.
You want time?
Yes, sir. And along with some past matter based on repetition similar matter. So I create that matter type with that those matters. I giving provide the number, my lord.
Call this matter 16. Item number 18. Call this WP along with WP number. Use that.
My lord, in the above case, my lords, I am appearing for 1 and 3, my lords. Take them.
Which?
This matter, my lords, item 18, my lords.
No, 18 you find Wakalat in the office.
Yeah.
My lord, item number 26.
22.
26.
26.
On behalf of N Panda. My lord, kindly adjourn this matter 1 week after, as the senior is not there, out of station.
All right, 3 weeks at the request of counsel for that.
Your Honor, I am paying for item 44. Item 44,
Matter of the year 2022 minus the petitioner's application for appointment under rehabilitation assistance has been rejected. Petitioner's application for rehabilitation assistance rules for appointment under the rehabilitation assistance has been rejected.
22, my lord. 2022 matter, my lord. Still pending, my lord. Take that. In the first week of October. In the first week of October, we do that.
May I make a mention? May I make a mention? Your Lordship, may kindly see this order.
Take it.
That school who had given compulsory TC to the child. Your Lordship specifically fixed today.
Post is on 12th August.
My Lord, the office,
Call it tomorrow.
office doesn't care for judicial orders. What can we do, madam?
Who is responsible?
I'm filing a memo, madam.
Take care. Tomorrow. Ask who is that officer? Even when there is an order, he does not. Does he want money? Does he want money for posting? Who is that officer? Call that officer. Ask him to come to court. Let him face the lawyers. Ask him to come. Who is the person responsible for posting? Memos are moved, memos are accepted. You do not push the matter. You want to sit above me as in appeal. Ask that concern to come and stand before the court. That's the only way. I cannot just more threaten them. Let him be shown to these people. They will know what they will do. Call that officer. Why it has not done? Call registrar judicial here. Send what? Send for him. Call judicial registrar.
Your Honor, I mentioned for the item 44.
Yeah.
Item 44, the advocate.
Some gentleman was, elderly gentleman was asking something. Yes, sir.
Yes, sir. I'm adjournment in item 44. The advocate is sick.
In 44, you want time?
Yes, sir.
You are for a petitioner.
Advocate SR Pine.
You are for whom?
SR Pine advocate.
Appearing for whom?
Petitioner.
Petitioner. But there are 4 matters which I have read and come now.
All matters, I press for adjournment. The advocate is
44. Week after next, 44. At the request of arguing counsel on the health ground. Yes. Call. Any adjournment?
No.
No adjournment. Yes, call the cases.
Item number 1.
Item 1, my lord. Matter related to grant the benefit in terms of the government resolution.
as per the government resolution. So similar matters are there. In this case, counterpart was not filed. Other cases are filed. So we'll also like to come along with other cases, similar matter.
Call this
Tomorrow,
matter
tomorrow day after tomorrow.
It will come which
Yes.
matter. We don't know what is the date fixed in other matters. Yes, call along with WP number at the request of counsel for the petitioner. Yes, kindly, I have a request. Take maximum benefit of non-filing of objection statement. There are judgments of the apex court which say where no objection is filed, court may take the petition with you. Bring that judgment. Why do you want the objection statement? Ensure that he does not file the objection statement. That helps you. Yes. Item number 2.
Retirement benefits of web typist. Well, this matter was disposed of, in fact, and this I have filed a contempt application for non-compliance. Thereafter, in the contempt application, state has filed a show cause that writ appeal 2156 of 2023 has been filed. And this is in terms of the
What happened to writ appeal?
what they have writ appeal, no copy has been submitted.
Why? Sir, why order is not complied with, sir?
Sir, contempt application was dropped.
Stop.
Yes.
Why?
Your Lordship may kindly have a look to the brief, my lord. My lord.
What was the order?
Lordship may kindly have a look. Approval of the contention of the petitioner, my lord, is that he was superannuated from service on 28 to 2023.
No, what is the order? What was the order which you were required to implement?
My lord, it requires he is claiming for pension.
Where is the order?
In terms of Sarath Chandra Parida's case. Now, my lord, the matter is in session of hearing in case of Hemant Chandra Chotrai's case in a division bench of writ appeal. Yesterday it was there. So let it come thereafter, my lord, so that you will get the benefit.
Is it stayed?
My lord?
Is there stay?
No.
Then implement the order. In the event you succeed, get back the...
My lord, recovery part is something different to recover the money. Lordship, there is no contempt, I think.
But two contempts have been filed.
But where is the order which you are complaining order is violated?
Which order?
This is the writ petition, my lord.
What I should do with the writ petitions?
The order, I annexed the order in a contempt petition, not here.
In the
Because the case was disposed of, my lord.
Two cases are 11.
No, writ petition order ta dekho. It has.
Tomo writ petition, you have not referred anything.
Writ petition, I mean, writ petition that the content is order ta bola.
No, writ petition, you have not awarded anything even for the writ petition. Why you are?
Writ petition was disposed of earlier.
He was a block grant employee. His claims benefit of Sarath Chandra Parida's case.
It was referred to, remitted to learned single judges bench. In writ appeal number 2156 of 2023. What the learned single judge did?
It was not hard, my lord. Again, they have filed another writ appeal state government in Hemant Chotrai's case, which is now.
No, that is different. This is not in accordance with this case, particular case. Sir is putting you a question, what about this case? Hemant Chotrai's case is a different case. Another case of
question in your favor to say that there is contempt.
As these orders was not complied, I have filed a contempt. 19/4/2023.
19/4/2023.
I have annexed this order in a contempt petition, my lord.
Is it in your writ petition? That order is made in your petition?
Yes, my lord. 11/5/39/2020. The case which is listed today. This was already earlier. It was disposed of.
But learned AGA is saying that the matter is now pending before the division bench.
Batch
was heard yesterday.
Yes, that is
batch matter. Another batch matter.
Batch matters are heard yesterday.
It was adjourned again.
Your client is Gangadhar Raut.
Yes, madam.
In this, what was the order? Brother, there is a positive direction.
My lord, Lordship, can I suggest, my lord? Let him give representation to the authorities so that they can take care of the matter in accordance with that Sarod Pareda's case or Hemant Chotrai's case, so that the matter can be disposed of, my lord.
No, where is the question of there is a positive direction.
Yeah, I do not know. I do not know, my lord.
You should give a copy. You are giving it as if you are giving something in the tea shop.
My lord, this was also there is this case. No, that is not a part of this record even.
How he will know? Anyway, all right. You don't argue with him. Argue with me. Government advocate is doing his job. You should not argue with them. You should respectfully treat them.
Yes,
brother, there is a direction, positive direction to extend but the
pensionary benefits and or retirement benefits to the petitioner within 4 months from today.
There should be a representation.
No, there should not be, but
there not be. There should not be.
There should not be.
Who is the officer? Who should have?
But and again,
you will come back after having conferred the client.
Yes.
Learned AGA on being confronted with a coordinate bench order dated
19/4/2023.
23. Entered in writ petition number
11539 of 2023.
Submits that he would confer with his official client and come back with some positive response, in as much as the order directs not only consideration of prayer for grant of terminal benefits, but the mandate to grant the terminal benefits. First, when do you want?
After 2 weeks.
1 week will be.
1 week, yes.
Call this matter on Tuesday. Next. Item number 3. The concerned officer is warned in advance that some stringent action may follow if it is found that the order is not complied with and there is no justification for non-compliance. I may impose 1 lakh rupees cost. Therefore, I have put you in warning now. Yes. Item number 3. Yes, call the judicial.
Yes, the writ appeal has been filed by the state matter, and in the writ appeal it is remanded back.
Matter is remanded to this court now.
Yes, madam.
Sir, are you ready?
What should I call this matter? Next week I'll argue the matter.
23 matter.
Yes.
This 2-year-old matter is called after, he is being called after 2 weeks at the request of learned AGA, who assures that he would prepare himself to argue the matter.
Yes.
Call this matter after 2 weeks.
Item 39 also same.
39 also?
39.
Can be called along with this matter or a different matter?
It is along with
along with this matter. 2 and 39. Next. Item 4. Yes.
Listen, sub item. Here the status file counter.
Please be loud.
Let's
be loud. LOVD and LOUD also.
The matter relating to regulation of service.
Regulation
of the service. The petitioner appointed as a CKSA in the year 2014.
First time it has come.
No, the main item it is directing to taken up along with the sub item. In the sub item, the state has filed the counter. Lordship, I have annexed the Annex 3, the input order passed in respect of the other way. Here there is no bar. There is no
how many years you have served?
In the year 2014, that is filed Annex 1.
2014.
Lordship.
You were appointed on contract basis.
Lordship.
Any interview, something happened?
No, they issued the engagement order. Engagement order.
No interview, nothing.
No interview.
Because
on the basis of meritorious candidate, they have issued the appointment order.
You were found meritorious.
Lordship.
Annexer?
And Annex 1 running page 18, Lordship, 1-8.
Brother, look into and file your statement of objections.
My lord, I cannot follow.
No.
We'll find it.
You have filed objection.
We have filed, my lord.
Some items objection has been filed by this time.
One
The
week
connected
after. Yes.
You want to
after-
adopt it in this matter also?
Yes, my lord. In lordship, may kindly call this matter 1 week after, whatever. The lordship.
The second week of September. At the request of learned. Item 5.
May I please, Your Lordship?
Yes.
Pursuant to an advertisement under Annexure 1 in the year 1996, the petitioner for the post of primary school teachers, appointment of primary school teachers, my lord, the petitioner applied, my lords. Page,
He was appointed on which day?
no, applied, my lords. Page
Applied.
21, yeah, is the advertisement, and the petitioner applied, my lords. And she was also empaneled in the list, my lords. I am coming to this, my lords.
Then what?
Then, my lord, they didn't consider. In the year 2005, my lords, at page 26, they engaged her, my lords, as a Sikha Sahayat, my lords. 2005, my lords.
2005.
Yes, lords. And
Now what you want?
my lords, my lords, this in spite of my name finding place in 97 select list, 2006 select list, and 2012 select list, the petitioner was not granted the benefits since 97. Rather, they have annexed 13 milliards. I approached this honorable court. Even I approached the learned tribunal in the year 2007. At page 27, it is there, my lord. And learned tribunal said that, and they considered before the tribunal that yes, we are adjusting the panel, but they didn't consider, my lords, and they simply rejected my case, saying that your name doesn't find place in the panel. When I obtained under RTI in the year 2023-24, my lords, my name finds place, my lords. Now I have retired since 2024, my lords.
Having served how many years?
My lords, since 2005, my lords, it's 19 years. But if your lordship, one line, my lords, one.
But you were not engaged earlier.
Yes.
I was engaged in 2005, my lords. I applied in 96. My name finds place in this selection.
That your name was.
Now, my lords, I only claim, my lords, even though the persons who have secured less mark than the petitioner, I have obtained those documents and filed before your lordship under RTI. They have given the benefits from 97. That is my case. And
Though you have not worked.
No, I am not saying I am not. I have worked since 2005, my lords.
You are only misleading the court.
No, I say, my lord.
Did you work before 2005?
No, my lords.
You have not worked.
Yes.
But you want the pension based upon that period
My
of.
lords, even for, my lords, 2005, my lords, my lords, even for 2005, my entry in the service, what I bring to a lordship's notice, my lord, when my name finds place since 97, and they should have given me that benefit 97, but I have worked since 2005, my lords. That is no case.
You have worked. Other earlier you have not.
That, my lords.
No work, no pay.
That I am conscious, my your lordships. I leave it to a lordship, my lords.
Now, if it is taken as 2005, you already having retired.
Yes.
What benefit court can grant?
My lords, to pension benefits and these increments, my lords, they have provided to others, my lord, who have approached this court, my lord, along with me in 2007. That is also my case, my lords. Page 27, lordship, see, my lords. I have approaching since 2007.
Yes, brother, what do you say?
My lord, there are two recruitments. One is pursuant to, I think, no counter has yet come in this case.
To file counter?
Yes, I am to file a counter in this case.
Yeah, even in cases where appointment was.
That is in the year 97, what he claims, my lord.
But there was appointment.
There was appointment pursuant to 23.
Process was not appointed.
He was appointed pursuant to another advertisement. That is meant, that's a schematic one.
AGA. You are AGA?
Yes.
AGA, learned AGA, Shri. 3 weeks time to file objections. 3 weeks given. Call after 4 weeks.
Let's lords.
Item 6.
Compliance done. There was an order dated 14/7/25 to comply with the office requirement. None appears for petitioner. Call after 6 weeks. Yes.
Item 7.
May I please,
Yes.
the second time that matter has been come. Last again, it's a family pension matter. Last occasion, learned counsel for the opposite party took time to file counter and take instruction.
Any counter is filed now.
Not yet filed. They have appeared last occasion. The Barampur University, Dr. Chuli.
My lord, I am appearing for Dr. Pushottam Chuli and the opposite party number 1, Barampur University, and opposite party number 2, the registrar. My lord, my humble submission is that the petitioner is not eligible for family pension. My lord,
Wait, have you filed objection statement?
No, my lord.
You don't want to file, just orally you will send him away.
No, my lord, I want to file.
For objections. 2 weeks time finally granted at the request of panel counsel appearing for the respondent university. Failing with no right to, the right to file one stands for it. And petition may be taken up with prima facie value. Call up performance.
Item 8.
I may be pardoned, your lordship, my lord. This is a matter with regards to street vendors, compensation to them under a scheme. I think it is probably a division bench matter, your lordship.
Division bench.
Matter has to go before the division bench.
Yes, your lordship.
It is submitted at the bar unanimously. That matter to be posted before the roster division bench. First up, registry to look in. Yes.
Item 9. Item 9.
Yes, sir.
Some illegal constructions were made before the present petitioner by the opposite party number 8 and 9, your lordship.
What's your prayer?
So the present petitioner filed a recommendation under Annexure 1 to inform the opposite party authorities. But till date, no action has been taken.
What is that you have sought for in the representation?
My representation is that to remove the encroachment in front of my house, lordship. That is my recommendation. But till then, no action has been taken.
But who has encroached?
Some public and as well as government authority also.
On your land?
Lordship, in front of my land, not on my land.
On public property?
On public property.
Well, government is constructing a bus stand in government land. And is...
But he says that there is some encroachment, etc.
No encroachment. No encroachment.
Yes, for that reason, my land has been encroached.
Not encroached. He has stated that ingress and outgress is obstructed. That is his case. Not that it is
But at least ensure that the ingress and egress to his house till construction takes place is not affected. Otherwise, how he should gain entry? How the women, folk, children will be inside in the house?
My lord, let
consider that
representation.
The short grievance of the petitioner is as to the alleged obstruction to his ingress and egress to the residence in question. First time. Counsel for the petitioner submits that there is a lot of disturbance taking place because of some construction taking around in the public property, and that is causing this obstruction, and therefore he has made a representation which remains unconsidered. First up, he seeks intervention of writ court. First, next paragraph. Learned AGA having resisted the petition for some time on the ground that the grievance of the petitioner should be worked out before a civil court, now graciously agrees to instruct his official clients to look into the grievance of the petitioner as has been aired in the representation dated
7/5/2025.
7/5/2025 at Annexure
1.
In accordance with law, if all grounds are reserved. First up, the counsel for the petitioner is agreeable with this proposal. First up, next paragraph. In the above circumstances, the petition is disposed of. Time for consideration of the representation and to inform of such consideration to the petitioner is 8 weeks. First up, all contentions are kept open. It is open to solicit, etc. No costs. Next.
Obliged.
Item 10. Yes, brother.
Here, my lord, the petitioner was working as a teacher in adult education, my lord. That is known as Preraka and Prerika in adult education program. My lord, subsequently, their post was abolished, my lord. They put their grievance before the secretary, my lord. The president of the union put their grievance. Considering their application, they under Annexure 5, they issue, they may be engaged in class 4 employee.
Annexure 5.
5, my lord.
What they say?
They, for engagement of class 4 employee.
They assured you class 4 employee employment.
My lord. Basing upon above, my lord, the petitioner filed a representation under Annexure 7, my lord. Page 6.
We are all retrenched workmen.
My lord. Prerak.
Class 4 in the district education officer.
My lord.
You want alternate employment?
My lord.
How many years you had put in service?
My lord, 5 years.
Where is that? Where have you stated?
My lord, but their retrenchment order has not been issued, my lord. Engagement order is there, my lord, but disengagement is not issued.
No, we are asking you. I'm asking you. How long your clients are working? And your association is before the court.
Yes, my lord.
On what ground? How association can
petitioner is not association, my lord. Petitioner is not association. He himself also working. Petitioner is herself working, my lord.
In identical cases, my lord, notice was issued. We had filed counters. Batch of case or number do
identical matter. You are telling the question. Issue emergent notice. Learned AG is requested to accept notice for the respondents. First of call this matter along with WP number. So
Item 11.
in the second week of October.
This time.
Huh?
I pray for times.
What for? What is this matter about? Just tell me.
License of the Mohammedan marriage and registration.
Mohammedan marriage registration.
Subject to my lord's permission.
Be loud.
Subject to my lord's permission. The lead. 3 cases are the lead cases. In the 3 lead cases, counter is under, everything is ready, man. And if my brother is paying for time,
In my case,
his case is fresh case. His case is fresh case.
You are for whom?
I am for one of the read petitioner, my lord.
Read petitioners.
Batch of cases there.
Let him argue the matter.
Sir, my case is the first case, that is 17.29 of 2025.
Correct. He will argue the matter now, other matters. And you, if you want to add anything, you add sitting beside him. Why it should be urgent unnecessarily?
Sir, I want to take some materials on this. I have instructed my client to this. That's why I'm praying for time, my lord. So let's get this.
Solve this matter in the last week of third week there will be vacation, perhaps not holidays. In the second week of September, at the request of counsel. Are you Usman Khan?
Yes.
Counsel Usman Khan. Okay.
Advocate of Mr. Osman.
All right.
Item 12.
Wait, please.
Yes, sir.
And here the short fact of the case is that the villagers, the petitioners are the villagers. They've been authorized, these petitioners, to file this writ petition. They are the villagers of Korodakonta village. There is a village named Korodakonta. For your lordship's appreciation, kindly turn to page 29. That is sketch map. So it will be easier for me to
29.
page 29. Yes.
Go to 29. It is a Like
Rock map, yes, that is a graphical representation. The NH that is going from Bhubaneswar towards Puri. The first there is Bhubaneswar and last is Puri. There is a middle Pandera square. If you also kindly sees Pandera square. That square.
Pandava square or
P-A-N-D-A-R-A. That is not array. Pandera square. Yes. Thereafter, after 2.5 kilometers, there is an unnamed square. That is the Jharpada Korodakonta road. That square is unnamed. Thereafter, after again 2 kilometers, there is another square, that is Sai Baba Temple Square. So the villagers, they wanted the square to be named as Korodakonta Square or any name.
Every square should be named.
No. The problem is that the ambulance service, in case of emergencies, the ambulance service cannot reach because that square is unnamed. So the villagers are facing immense difficulties in identifying that square.
It is on the straight road, huh?
Yes, straight road. That is on NH.
1 second. Straight road. X, Y, Z. 3 squares are there. X is named, Z is named. Y is not named. Can't you say the square that is in between these two? Where is which law says every square should be named?
But that is on NS. So, Your Lordship, that is not the subject matter here. It is that, Your Lordship, the villagers wrote to the Works Department, the state entertained their representation. And Answer 5, page number 30, my lord.
And what it said?
It says the Works Department, they wrote to the Director, Odia Language and Literature Department in 2021 that the naming of the squares does not come in under our domain or jurisdiction. So you take
what's your right? What is your right? That every road should be named, every square should be named, every dog should be belted. What is your right?
So after coming in 5 kilometer distance, 5 to 6 kilometer distance, there is no naming of the square. So
I'm asking you,
ambulance service and in case of emergencies, the ambulance is
you defeat your concerned MLA in next election because he has not named. How can court come to your aid? Court cannot. The short grievance of the petitioner is not naming of a particular square on is it a national highway?
Yes, Your Lordship.
On a national highway which leads.
My lord, my representation is pending, my lord.
We'll reject that representation now.
National highway number 3.
National highway number 316.
If Lordship, if the matter can come another date, I'll satisfy Your Lordship with
fully satisfied. I'm fully satisfied that there is no case in this one only. What can we do? We have to go read court. No right, no read. Simple principle.
Well, let it come another day. Your Lordship will
not waste time. We have already wasted time.
No, otherwise I will be misunderstood by my senior.
No, otherwise you have to have it. That happens. Every case, how can you win? Did you assure your client that you will win the case?
No, that is
yes. Highway. From which place to which place it is?
It is from Puri to Bhubaneswar to Puri, my lord. That
which runs from Bhubaneswar to Puri.
Bypass.
By way of bypass.
Bypass.
By way of bypass. First time. Next paragraph. Learned counsel for the petitioner submits that though a representation has been given to name the particular square so that it becomes easy for the villagers to avail the services of ambulance, etc. No decision is taken on the said representation. First, when asked which law gives right to villagers to seek naming of every corner and square, learned counsel for the petitioner feigns ignorance. First, be that as it may. Next paragraph. Learned AGA having they should take some decision.
Yes.
Learned AGA having opposed the petition on the ground of no read inwards, comma, now fairly submits that he would instruct his officials to look into the grievance of the petitioner.
Annexure 2.
As has been reflected in the representation at
Annexure 5.
Annexure 6 here also, represents the Annexure 6.
5 and 6? 6.
6. 5 is the interdepartmental communication. 6.
In accordance with law, in a time bound and in a time bound manner. First, this should satisfy the counsel for the petition. Next one, with the above observations, petition is disposed of. Time for compliance is 8 weeks. It is open to solicit, etc. Okay.
What's obliged?
Web copy to be acted. Okay, that's a standard inscription. Okay.
Obliged.
Item 13.
13, may I please, my lords?
Yes.
This is small matter, my lords, regarding grant of certified copy, my lords. Your lordship may come to Annexure 2, my lords, running page number 13.
You want certified copies?
My lords.
Of which document?
My lords, of the entire order sheet in the family court matter, my lords.
They are not giving to you.
No, my lords. I have applied since 3/4/2025. They are saying that the file cannot be traced, my lords.
But if file is not traceable, what can be done?
My lords, reconstruction of the file, my lords.
It is are you a party to the proceeding?
My lords.
The register.
Huh?
Yes, Annexure 2 is application.
And it is pending since, my lords, 3/4/2025, my lords.
If that is considered, that will be sufficient.
My lords, a direction be given for consideration.
Okay. The short grievance of the petitioner is as to non-consideration of his copy application filed in the prescribed form, seeking certified copies of certain documents relating to which case it is.
My lord, CMA case number 16 2018.
2018.
Arising out of CP number 200.
Arising out of CP number 213 of 2016. Between Anima Pradhan versus
Santosh Kumar
Champati. First up. Next paragraph. Learned counsel for the petitioner submits that his client happens to be one of the parties to the subject case, and therefore he is entitled to have copies of the pleadings and such other documents from the file. And that
Order sheets.
order sheet.
I prayed for only order sheet.
Sought for copy of the order sheet in the subject cases, and the same has not been furnished despite application for an indefinite period of time. First law. Next paragraph. Learned AGA appearing for the official respondent resists the petition, contending that it appears the file has been misplaced, and therefore, till the same is retraced, it is not possible to consider the subject application. First up, having so contended, he agrees with the suggestion of this court that he should confer with the jurisdictional authorities for rebuilding of the missing file if necessary, and thereafter to issue the certified copies on that basis. First up, this has to be done in a time-bound manner, since citizen cannot be made to wait indefinitely. First, next paragraph. In the above circumstances and with the above observations, petition is disposed of. First off, time for compliance is 8 weeks. I'm grateful.
Judicial authority, that is opposite party number 2, register district judge Khurda.
He has to create that.
Yes. He has to reconstruct the file and
whichever, we don't know. There is for reconstruction, there is a whole lot of procedure.
Yes.
He has to take permission of RG and consult judge. So many things are there.
So register district court for you. Opposite party 2.
If the file can be traced out, then OP3 can also grant it. So let it have. Grateful, my lord.
Next.
I'm grateful, my lord.
Item 14.
May I please, Your Lordship? Here the petitioner is a senior technical assistant
at Mechanical Engineering Department, Your Lordship, at IGIT Saram. Your Lordship, challenging the rejection order under Annexure 8, Your Lordship, where it has been rejected on the ground that the petitioner has already availed 3 financial upgradation within 30 years. Whereas the similar person, Your Lordship, kindly have a glance to the Annexure 3.
How many they have got?
They have got more than 3 upgradation within 30 years of service.
No, which is there? They might.
Yes, Your
You
Lord.
have to show. They have got it and they had right to get it. 2 things you have to show. If they have wrongly got it, a wrong does not give a right in your favor.
Yes, Your Lordship. So far as fitment principle is concerned, Your Lordship,
Which is that?
kindly have a glance.
How many you should get according to you under the policy?
Lordship, only 1 increment, Your Lordship.
1 increment.
Yes, Your Lordship, which I have been deprived. Though I have been fitment in the next level, but the increment which I am entitled to, that I am losing, Your Lordship. Therefore, I am before Your Lordship. Your Lordship, kindly have a glance to the page number 19.
They have rejected.
Yes, Your Lordship. Annexure 8, kindly have a glance.
Annexure 8.
Annexure 8, page number 42.
On what ground they have rejected?
They have rejected on the ground that you have already availed 3 financial upgradation within 30 years, so you cannot get further. But I am not claiming for further financial upgradation. I am only claiming for 1 increment.
Where have you sought for increment?
Yes, Your Lordship.
You have sought for pay metrics.
Yes, Your Lordship. Your Lordship, kindly have a glance to the Annexure 1, Your Lordship. First. Your Lordship, I have availed RSCP 2 and promotion 1 in the column number 4, Your Lordship. That is.
Take notice you have given to many others. Many others you have given already.
The grievance is against the opposite party number 2 and 3.
2 and 3.
Yes, the Indira Gandhi Institute of Technology.
Issue emergent notice. Returnable within 4 weeks. Okay. Grateful. For 1 you are appearing.
For 1.
1 AG. Yes, next. Item 15.
May I please, Your Lordship?
Yes.
The petitioner was working as the assistant teacher and he has dismissed from service on the ground of misconduct on duty.
What was the misconduct?
That allegation was bigamy. That has been proved by neither the police or in the department. That only allegation. That has been on that ground, he has been dismissed from the service.
When?
In the year 20, my lord.
2020.
Yes, ma'am. That he has preferred an appeal. In appeal, he has preferred an appeal before the director.
Departmental appeal.
Yes. That appeal was allowed and that order passed by dismissal has been passed. Thereafter, he has filed an application before this Hon'Ble Court to grant him all the service benefits.
Has he retired now?
No, that is in continuing. Thereafter, my lord, that he has sought for instruction.
How many years you were away from service?
That have not been calculated, my lord. But he is now continuing. But under that period, the dismissal period shall be treated as they have hold that the dismissal period shall be treated as leave.
As leave?
Yes. My prayer before Lordship that period should be treated as duty because of their part I have as per the 91 of the service code. So if he has been fully exonerated.
Take notice.
Yes. That is clearly said he has exonerated that he should be treated as duty. That acts says.
Let us see.
Short.
Any representation given? No given. No representation because order is there.
Yes, yes.
Take notice.
Yes, sir.
Emergent notice. Yes, returnable within 4 weeks. Yes.
Item 16.
My lord, item 16, my lord, on behalf of Mr. Jana, kindly pass over. Yes, I'm passing.
Pass over?
My lord.
What is the prayer?
I have not gone through the brief. He has telephonically requested.
Provision of appeal is there. Yeah, challenge the legal error certificate issued by the revenue officer.
Pass over.
Kindly pass over.
Item 17.
May I please, my lord?
Yes, sir.
The petitioner is challenging the order of the appellate authority wherein the unauthorized absent on the ground of
unauthorizedly absent.
on the unauthorized absent
From which place?
on
What period?
long period from 28/8/2007 to
28/8/2007 to
18/8/2008 on medical ground.
18/8/2008. What was the medical ground?
Well, I was suffering from viral hepatitis.
In which hospital you were taken?
SCB Medical College and Hospital. Thereafter, the one professor of SCB Medical College and Hospital, I annexed the document therein. The landed authority were while rejecting the. I have going on making the application, leave application at the initial period. My humble submission, my lord. At the initial period, they have not made any order with regards to my leave application. While I have filed an application for resume my duty, they have not at all given any order with regards to the consideration of my application for resume in duty.
Where was that leave application?
My lord. Annexure 4 is my application, page 24.
But it was not a medical leave, it was a CL.
CL. I am a contractual employee. I have written CL, but I was not entitled to CL, madam.
But you have written CL.
I have written CL.
Where have you mentioned, I am not well, I cannot come to duty for, therefore find permission to stay away?
No, I have stated, madam.
Where is it?
At page 24.
For the treatment of the same.
Unable, I am suffering from severe chest pain, which is very unbearable and very painful, for which I am decided to go to Cuttack for treatment for the same. Under this circumstances, I need 3 days CL from that is 28/8/2007 to 30th/8/2007. Then thereafter, I have.
What were you?
I was at Balasore in the.
No, what was your designation?
Data entry operator contractual.
Now, suppose if 1 year if you go away, how institution should run?
My lord, that is also a fact, my lord. Your lordship is correct, my lord.
Then you have no case.
My lord.
You may have genuine reason to stay away.
My lord.
But they cannot wait till you come back because we have to run the institution.
Yes, but my humble submission for my lord's consideration is that I am a person waiting for justice since my date of resume, my lord. I have come to court two times. Honorable court has directed to approach the appellate authority. Appellate authority has been passed the order that as per the rules, you are not entitled for reinstatement. Correct. That is their rules, my lord. I'm also admitting, my lord. But they have to pass the same order at the initial stage, my lord. I have waited for a long time.
Why did you wait? They have waited for you quite long. 1 year. Suppose if a judge goes 1 year and comes back to Orissa again, will you entertain him?
That is also a fact.
I am accepting the place where you were.
So I very fairly I am accepting.
That's what, but you are very fair. I appreciate your fairness.
Madam,
but in law you
have an alternative prayer before my lords. If your lordship may kind enough to pass the order to the opposite parties, opposite party number 2, my lord, for any alternative engagement, because I am waiting for a long time. I am a young.
Can I?
If
you have made me judge, you have taken
I may be allowed to make an application.
Oh, no, how that will be? You have no case. You have made me judge because I will decide the things according to law.
Well,
I am not Mughal emperor.
But I have
an alternative
to you. I have also an alternative prayer. If your lordship may please to give an liberty to approach the authority.
Opposite party 2 to be noticed. Opposite party 2.
What do you want to say?
No, that is
one liberty.
What liberty?
We are not. State is not appearing for opposite party 2 and 3. 2 and 4.
Who are they?
The State Director, Odisha Primary Education Program Authority. They have one panel.
Petitioner is grieving before the court as to non-consideration of his request for re-engagement on the ground that
I beg your pardon. Sorry, now.
engagement on the ground that he was away from duty for about a year during the period between 28/8/2007 and 18/8/2008 on account of ill health. And having regained health, he requested the employer to get him re-inducted in the service, which he is not agreeing to. First up. Next paragraph. Learned counsel for the petition. Kindly be seated. Vasant. Learned counsel for the petitioner very effectively submitted that virus and bacteria do not spare human beings, and that his client was suffering, for which he underwent treatment for about a year or so. And during the said period, he could not be in the employment. He stripped. He also submits that no prejudice will be caused to the other side if the petitioner is re-inducted to service as a data entry operator. Yes, entry operator. First. Learned AGA appearing for the respondent opposes the petition, contending that every institution needs working hands. And if some hands go away for a year or so, unauthorizedly, the efficacy level of the institution gets diminished, and that would affect the public interest. And therefore, the rejection of petitioner's prayer for re-induction in service cannot be granted. First, I agree with this. Next paragraph. In the above circumstances, petition being devoid of merits is liable to be and accordingly dismissed.
Can I?
First, this order shall not come in the way of the official respondent being bit lenient in considering representation of the petitioner in some alternate appointment, if possible.
Some post are also lying there.
Item 19.
May I please?
Yes, sister.
The second litigation, my lord, annexure 8 is
Annexure 8.
8.
Annexure 8.
Rejection order.
What is rejected?
Representation. The representation is rejected.
Representation for getting married. What is the representation for?
Similar order, my lord. Not the first. Listen.
We have already issued notice.
Yes, my lord.
Issue notice. AGA.
Yes. Government order.
Union opinion.
First, second, 3, 4, you only. AGA for all respondents. Call in the third week of October. Along with WP number. Give that WP.
Yes, item 20. 2204.
Your Lordship, the petitioner herein is aggrieved of administrative inaction against an illegal appointment being reported against respondent 5, 6, and 7.
Illegally appointment is given.
Yes.
To 6, 7, 8.
5, 6, and 7. And
what is the post?
First, they have been appointed, respondent number 5 and 6, they have been appointed as education volunteer. And that was also illegally been appointed. And another one,
You don't have Lokayukta here.
Yes.
No Lokayukta.
Yes, sir.
You have Lokayukta here. In Lokayukta Act, there is any provision for complaints of the kind. Which is that Lokayukta Act? Give Lokayukta Act. It's a maladministration.
Yes.
You go before the Lokayukta.
It's been 7 years. We have the petitioner has been finding out all the information.
Why
And
you
we have-
collected all the information now?
Yes.
You will go now for the Lokayukta. After they retire, if you go, it will not help you. Is it not? They have been working since how long?
One of them has been retired and is collected. Respondent number 7 who has given a wrong caste certificate, and another 2 they are continuing as a regularized primary school teachers.
On the basis of caste.
Yes, ma'am.
On the basis of caste status.
Only one respondent number 7 on the basis of false caste certificate, and another respondent number 5 and 6. Both of them have been illegally been appointed with some back papers, and they have done some fraudulent paper drills.
How you are concerned with that?
Sir, I am as a petitioner, I belong to the same block where these all fraudulent activities have taken place, and I'm also a trained primary school teacher from that block.
You are retired now.
No, sir. Sir,
Still working?
I'm a 26-year-old student who has also completed his primary school teacher education, and he's pursuing his MA.
You have given a representation.
Yes, sir.
If that is considered, you will be happy.
Yes, sir. We are just praying for an impartial and thorough investigation upon the matter.
See,
We have all evidences with us also.
Brother, he is saying somebody is wrongly appointed.
Yes.
Just look into it. The short grievance of the petitioner is as to non-consideration of his complaint, as to alleged illegal appointment of private respond OP numbers 567.
Yes.
First, counsel for the petitioner submits that when a representation of the kind is given, the competent authorities cannot sleep over the same, making it a pillow endlessly. First off. Next paragraph. Learned AGA on request of appearing for the respondents assures the court that his representation would be met due consideration at the hands of jurisdictional authorities in a time-bound way and in accordance with law. If all the contentions are kept over. First off, counsel for the petitioner is agreeable with the same. First off. Next off, in the above circumstances and with the above observations, petition is disposed of. Notice to private respondents having been dispensed with in view of innocuous nature of order. Okay.
Highly obliged.
Time for compliance is 3 months. It is open to solicit sides. No course. Yes.
Item 21. Highly obliged.
Okay.
The matter of regulation for Ganashikshak, my lord.
Ganashikshak. Regularization.
My lord.
How many years he is in service?
My lord, Alistair 1, as we entered with Ganashikshak by the order dated 6th June 2008. But thereafter, under Sir 2 running page 14, he has been regularized.
All right.
He has been regularized.
All right. We'll issue notice now. Your objection?
No.
No objection. Issue emergent notice for the DG is requested. Sort of notice for respondent. Yeah.
Item 22.
Diversion of project cost, my lord. Diversion of funds, my lord, from one project to another at the desire of the MLA is the subject matter of challenge in the present writ application, my lord. I will take your lordship. Who are you? My lord, I am an educational institution, private unaided educational institution, in favor of which CM assistant, Chief Minister's assistants have been given for construction of project, my lord. Your lordship may turn to page 20, my lord. Construction of 4 numbers of additional classroom, drinking water, boundary wall, toilet for boys and girls for a school, my lord. Government has taken a policy decision to give financial assistance to underdeveloped schools, my lord, by way of giving special grant that is called CM assistance, my lord, Mukhyamantri Swatantra Sahayata Yojana. Page 20, your lordship, turn to page 20. Page 20, I am placing, my lord, that with reference to the subject cited above, I am to release a sum of ₹1 crore only towards execution of sanctioned project as indicated on Annexure 1. The SICOM EO Jilla Parishad Baleswar is requested to release the said amount in favor of the executing agency toward execution of project, my lord. My lord, your lordship may see the points, you are requested to strictly adhere to the following conditions during execution of the project, my lord. Your lordship got that, my lord? Page 20, my lord.
For which it has been sanctioned.
Yes, just above the point.
What they have done? They have diverted to.
My lord, next page, my lord, 21.
Diverted to what?
Page 21, my lord.
I'm asking you.
Yes, my lord.
To what project they have diverted the funds?
Yes, my lord. Next page 23, my lord.
Read.
There are other projects, my lord. Complete other projects they have transferred, my lord. With reference to the letters of the cited above, I am to say that the following projects were sanctioned under the CM Assistance Mukhyamantri 2023-24. Now the MLA,
brother,
Baleshwar desires to divert the project to some other.
Wait, what do you say?
Well, I will take instruction because file has not been applied, so but the hard copy is concerned.
Issue emergent notice. First of grievance of the petitioner is against diversion of funds to unauthorized projects when funds were specifically allocated for a particular purpose. Matter requires urgent consideration. First of all this matter, week of the next.
I filed a miscase, my lord, that the operation of that order, my lord, should be stayed, my lord, during the pendency of the case. Annex 3.
Till next date of hearing, the Annexure 3 shall not be given. Annexure 3 order.
Yes, my lord. Letter number 1233 dated 2/7/2025, page 22, my lord.
You have to develop a little good skills of communication. Yes. Say of letter number 1233 dated 2/7/2025, copy whereof avails at Annexure 3 is kept under suspension till next date of hearing. All right. What judge wants, whether I am communicating to that, I am catering to that requirement. These things you have to keep in mind.
Yes.
Otherwise, where is the communication? I will say something, you will say something.
I have not got it. Sorry, my lord, I have not heard your lordship.
Item 23.
Ordered copy.
Item 23.
Ordered copy, madam.
23. The petitioner is in demonstrative, working as a demonstrative aided college man. He wants some benefits under the RHB scheme. Yesterday,
Similar matters we have.
yesterday were there. Item 51. Item 51, yesterday list, my lord.
Yesterday.
Posted to next week.
Next week. Do you have WP number? Why can't you get the WP number?
22,090 by 25.
Right now. Issue emergent notice or the accepts notice for respondents. OPs. Call along with. Yes.
Item 24.
Yes.
In this case, a plot was allotted in my favor as per the PPA scheme. And this plot was allotted in the year 1997 after following due procedure. And possession was also handed over to me in the year 1998.
You have to register the draft,
Well,
please now.
yes, of course, my lord. All the processes has been completed, but till yet, my lord, I have already deposited the lease deed.
They don't want to register.
Not, my lord. They are not.
Perhaps you have not done something more there.
My lord, as for their requirement, my lord, may I suggest one thing, my lord?
Within 2 weeks.
May I suggest one thing, my lord, as per your lordship's convenience, my lord. My lord, may I be allowed to file a representation before the concerned authority? They may be directed to dispose of my representation considering all those grievances.
They may not consider at all. I have not seen one case where they have duly considered and come before the court saying that, sir, you have made this order, we have complied with this.
That BDA, so far the OP number 3 is concerned, they have got their independent panel. They have to take a decision, Mr. Dayananda Mahapatra and others are.
Better, my lord, if your lordship my lord. I know, my lord, if your lordship's direction is there, they will definitely
do that.
Consider the.
Who is the counsel for your BDA?
Mr. Senior Advocate Dayananda Mahapatra.
Bring Dayananda Mahapatra. You take notice, I'll call this next week.
Next week. Next week.
It will be easier for them to dispose of this.
Anybody appears for from his office, just he will give a representation, you consider it. All right, for BDA. All right.
Associate of
His
let a copy be served that it will be easier.
Just now I will.
The short grievance of the petitioner is reflected in the prayer which he has scripted in the petition as under. Means prayer. Next paragraph. Learned counsel for the petitioner submits that even now his client is ready and willing to give an appropriate representation. And if consideration of that is directed, his client is hopeful of getting the conveyance in question, that is the lease deed, at the hands of second respondent VDA. Third respondent VDA. Next paragraph. Learned panel counsel Shri so appearing for the third respondent VDA assures the court that if the petitioner gives one such representation, the same shall be considered on a war footing in accordance with law. First up, this assurance satisfies learned counsel for the petition. First up, next paragraph. In the above circumstances, petition is disposed of, reserving liberty to the petitioner to give an appropriate representation, seeking the conveyance in question. And if one is made, the same shall be considered by the third respondent, OP number 3, within a period of 6 weeks. 6 weeks. First of all, contentions of the parties are kept open. It is open to solicit information, etc. No costs. Yes.
Item 25.
The petitioner is a Ganashikshava and challenging the order of rejection under Annex 6 for regularization of Annex 6, my lord.
What they have rejected?
My lord. And you have a glance, my lord, page 30, my lord.
But as a lawyer, you have to tell me.
My lord. My lord.
I will read. That's another thing.
My lord.
You cannot be regularized.
Yes.
How many years of service you have?
17 years. Around.
17?
Yes.
Issue emergent notice. With any connected similar matters, do you have a number?
No.
Issue emergent notice. Only Mohanty. Any other? No. The learned AGA Mohanty is requested to accept notice for respondent OPs. Call in the second week of 2 months. Okay. Yes.
Item 27.
May I believe your lordship?
Yes.
My lord, the father of the petitioner was while serving as a watchman under the Sambalpur University, my lord, was died on 26/4/2015, my lord.
Compassionate appointment.
My lord. And prior to that, my
Take
lord,
notice.
my lord, they have rejected on the ground of your lordship notice.
Who are the parties?
My lord,
Number 2 is the registrar.
one is the government. I will serve the extra copy. Number 2, Sambalpur University.
On request of such notice for first respondent. Who are the panel counsel for OP number 2?
OP number 2, my lord.
Emergent notice to
Sambalpur University.
other respondents. Next.
Item 28.
The lordship is short dead.
Right?
Short dead.
2 months, sir.
Post immediately after service. Okay.
And the order dated May 12/6/2025 passed by the appellate tribunal under the provisions of smuggler and foreign exchange manipulators 1956 is the subject matter of challenge, where the appellate authority partly allow my appeal and the rest part or passed by the competent authority has been confirmed. My lord, so kindly see.
What was the order?
The order to freezing my account for the property was acquired by the illicit ganja, my lord.
Release of ganja.
Because no opportunity has been given. Lordship, kindly see the competent authority who has granted me the notice and I appeared. At that point of time, I was in custody. Your Lordship, kindly see page 25. The page 25, order passed by the competent authority first, my lord.
Take notice.
Notice to the
Union of India.
opposite part number 6, my lord. The competent authority administration FCME, that is income Union of India, my lord. Opposite part number 6. Other part of the state government.
Who are the state government? OP numbers?
OP number 1 to 5, my lord.
2, 5. To Mohanty. OP number 6.
Union of India, my lord. The competent authority.
Notice to OP number 6.
IA is there, my lord.
What for?
Not to take any coercive action pursuant to the order passed by the employer.
No, in ganja matters we cannot give.
No, that is not the ganja matter. Because that is not because the order was passed by the appellate tribunal under my lord. That is the final order. Lordship has to adjudicate whether the freezing order passed by the competent authority, the appellate authority, is rightly. That is my residential house, my lord.
Application for interim relief will be considered after service. Okay.
Because they will make a court, my residential house.
Let us see.
Your lordship kindly see the order.
What? That will be attachment.
No, my lord. That is freezing order already passed. They will take a forfeiture, my lord. The next step is forfeiture, my lord. That's why I before this honorable court, my lord.
Which date they have fixed?
No, not that has been fixed. But the act says that as per the 68O, they have to follow the procedure as per the 68 as per the civil procedure. My ground is there, my lord. Now they have confirmed the order of the freezing, my lord. The next step is
order of freezing of account.
No, my lord. The house.
Freezing of house.
Partly allowed. They have told the property was sold, property was purchased by my mother in 2015 when the proceeding was initiated in 2022 before 6 years. As per 68C of the ONDPS Act, property is purchased 6 years back before the proceeding was initiated, then that cannot be considered as the for the freezing, my lord. That has been the finding of the London Appellate Court. But the construction which was made in 2005, that illegally sold, that has been constructed in 2022, my lord.
Not to take any coercive action pursuant to impugned order till next date.
Impugned order by Annex 3, my lord.
Annex 3.
Okay.
Okay. Item 29.
May I please, Your Lordship. My lord, here the present petition has approached this honorable court, my lord, challenging the action of the opposite parties by passing an order of recovery from his pensionary benefits after 4 years of his retirement, my lord. On the
You are in which category?
My lord, I have retired as a classical teacher. It's a Group C, my lord, post. As per the so far as classification made under the OCS rule, my lord. So far as Group C, my lord.
Whether Rafiq Masi applies to you?
My lord, Rafiq Masi applies to me because Rafiq Masi, your lordship.
CND.
CND in your lordship, in any case, it cannot be recovered from CND. Your lordship, they have categorized, your lordship, kindly see.
Which is that latest judgment came, na?
My lord, that is Yogeshwar Sahu, my lord. Yogeshwar Sahu, they have taken into consideration.
They have recovered now?
No, they have issued the notice for recovery, my lord.
You can show show card, na?
No, they have not asked for any show code, my lord. They have, your lordship, kindly come to page 78. They have directed me to deposit the excess amount, my lord, directly.
No show card notice?
No show code, nothing, my lords.
Issue emergent notice. Stay of recovery from the pension of the petitioner till next date of age. Who appears for ASC for
for all the opposite parties, the state one state council, and notice may be issued to OP number 5.
OP number 5. This interim order is granted, keeping in view of exploitation in Rafiq Masi. Give that citation and another Sahu.
Yogeshwar Sahu, I have already given the
judgment.
Mallards. Yogeshwar Sahu, Mallard, 25, Mallard.
Just give that.
Mallards. Rafiq Masi judgment, Mallard, I am also giving. Rafiq Masi, Mallard. So,
Yogeshwar Sahu refers to Rafiq Masi.
Mallards also refers to Rafiq Masi.
Yogeshwar Sahu. Okay.
My 30 is also same, my lord.
30 is same?
My lords, my lords. There is, my lord, they have my lord, no recovery pursuant to, my lord.
Item 31.
May I please?
Yes.
Here is a case where the petitioner before your lordships was appointed as a Hindi teacher
departmental proceeding to be quashed.
Yes,
Why?
because it is the first of all, it is without jurisdiction. The authority who has initiated the proceeding doesn't have the power to do it. Second, my lord, the rule under which he has done it, that is also not the rule applicable to me. Fourth is the ground on which the memo of imputation on which such a departmental proceeding is even conceived of is purely vague. Because, my lord, your lords may kindly see, your lords may kindly come to the Annexure 1 itself, running page 10.
Who has issued the proceedings?
The district education officer, Dhenkanar.
What is actually who is the competent authority?
My lord, here the case, he ceases to be the appointing authority and disciplinary authority once I have retired from service. But after my retirement, only after the approval of the government, a proceeding can be initiated against against a retired the pensioner
Under
Rule 7(2)(b) of the pension rules. Your lords may kindly see.
Is it true?
Yes. My lord, I have
It appears to be true.
Your lords may kindly see.
I believe you. No objection for believing you.
No, no, my lord.
Issue emergent notice. Stay of disciplinary proceedings at Annexure A4 till next date of hearing.
Okay.
First off, this interim order is granted keeping in view Rule
7(2)(b)
to 7(2)(b)
of the Odisha Civil Service Pension Rules 1992. Oh, blessed. Can I pray for urgent call?
Yeah, web copy to be acted upon.
Oh,
Yeah. Web copy.
Title 32.
well, since all the opposite parties are government opposite parties, the LMS copy is available in the LMS. So
You give one copy.
Yes.
You will need copies.
yes, they will utilize it.
The retired bank officer, my lords, had invested his entire life savings in a plot of land, and he has built his house, which has been duly sanctioned by the BDA. The plan has been sanctioned, the deviation has been regularized, and now he is, my lords, after his retirement, his entire life savings he has put into that.
Now what happened?
Now, they say that you had illegally filed a false affidavit while taking this plot of land.
Did you file a false affidavit?
No. My submission is that I'm not.
What is the format of the affidavit?
It's 39,
Go to 13.
page 39. That I or my spouse or any of my minor children do not own or possess any residential house flat in the jurisdiction of the municipal corporation area of Bhubaneswar.
You have outside.
Yes. Now my plot was located in Kalinganagar area, which might have been within the BDA area, but it was not within the BMC area. So the affidavit specifically required me to make a disclosure with regard to BMC area, BMC jurisdictional area, Bhubaneswar Municipal Corporation jurisdictional area. So, my lord, I couldn't have filed anything beyond it.
Number 10 notice. Interim order. Staying
My lord, Annexure 11,
dated.
29/7/2025.
Into the order dated 29/7/2025, a copy whereof awails at Annexure 11 till next date of hearing.
Great. Urgent copy of your lordships.
Okay, web copy.
Great.
You take notice.
Number 1, man.
Copy number 1. So emergent notice.
BMC and also BC.
Emergent notice to others.
BD.
Okay.
Great.
In this case, my lord, petitioner is seeking a direction from this honorable court.
Can your voice be heard by a person who is standing behind you?
Sorry. Here is a case for non-payment of pension and provisional pension. The man has entered into service in 1982.
Retired on?
Retired on 23. He entered into service on 3/9/1982.
Why they have not sanctioned your provisional pension also? Any disciplinary inquiry?
No disciplinary inquiry, nothing.
Issue emergent notice. Learned AG is requested to, ASC is requested to accept notice for the office. All office.
All office.
All office. Call in the second week of September 2025, since matter relates to null benefits and pension.
I pray the interim application is pending for provisional pension.
Let us see.
Let your lordship must say, let them take a instruction so far the provisional pension is concerned. But already 2-3 years have passed. I have been.
The jurisdictional office to consider request of the petitioner for sanctioning of provisional pension before the next date of hearing, in accordance with law. And pendency of the matter will not come in the way of that exercise being undertaken.
Item 34.
Rejecting the claim of the petitioner for being appointed as a schematic teacher, my lord. In similar cases,
judgment.
Yes. Not within your lordship issue notice and for the interim.
Emergent notice, interim order, as in WP number so and so. Follow along with it. Yes, in such notice.
Item 35.
Yes. May I please?
Yes.
But this is squarely covered by the judgment of this honorable court in the case of Dhananjay Charan De. Well, here what has happened?
2020.
Yes.
Matter let
2022 ILR Cuttack page 84. My lord.
From the date of
Yes. My lord, so far as Ganasikyaks are concerned, my lord, the government floated a scheme that Ganasikhyak scheme is co-terminus with Sikhya Sahayak scheme. So far as Sikhyakas are concerned, their services were regularized after completion of 6 years. So far as Ganasikyaks are concerned, their services were regularized after completion of 8 years. So in Dhananjay Charan De's case, it has been held that those Ganasikyaks having requisite qualification from the very beginning, their services will also be regularized after completion of 6 years of service, not 8 years. That judgment was also upheld by the Honorable Apex Court.
what do you say? You take notice and tell it next week. Week after next.
Well, may I suggest one thing? That I have made a representation to the District Education Officer Baleswar citing that judgment. Let the District Education Officer consider that.
That's right.
Annexure 4 is there.
Petitioner has a grievance in relation to regularization of his service, and he has scripted his prayer as under. Kindly be seated. Next paragraph. Learned counsel for the petitioner submits that his client has already given a representation dated. Kindly tell the date.
2025.
As an example, 4, citing the decision of this court in Dhananjaya Charan De versus State and Others, 2020, Volume 2, ILR Cuttack 84, which has remained unconsidered for an indefinite period of time. First off, counsel submits that under Article 350 of the Constitution, there is a duty cast on the public authorities to grant redressal to the grievances raised in the representations of the kind. First off. Next paragraph. Learned ASC appearing for the answering respondents, although initially resisted the petition, obviously agrees to instruct the jurisdictional official client to look into the grievance of the petitioner in a time-bound way and in accordance with law, keeping the said decision in view. First off, this is appreciable. Next paragraph. In the above circumstances, petition is disposed of. First off, time for compliance is 8 weeks, which would include communicating the result of such consideration. First off, all contentions of the parties are kept open. First off, it hardly needs to be stated that the subject representation to be considered in the light of Dhananjaya Charande case and other norms, if any. Okay. It's open to solicit, signed, so web copy to be acted upon. No costs. Yes.
Item 36.
May I please?
Yes, sir.
The petitioner has retired as professor in computer science and application 6/15/2001. But till date, he has not been given his pension, granted his pension.
Take emergent notice.
I have made representation on
You
the,
have given the representation.
yes, to the office department.
You worked from which time to which time? What during what period?
2005, Annex 5, I have made representation.
Which date to which date?
I have retired on 1st May 2001. But during their university dispute, your lordship can clear, your lordship can have page 47.
I am asking simple question, Doctor. During what period he was in service?
Till 2001. Till May 2001.
From?
From
Because whether he has put in pensionable service or not,
yes,
yes,
more than 14 years. That is from 13/12/1983. Sorry, 13/12/1983.
Perfect.
Well,
Kindly be seated. The short grievance, who respondents, opponents are by AC.
yes, mal.
You appear for the AC.
Copy number 1 is not there. Copy, LMS provision is there.
Anyway, consider the representation. I am not passing any positive order. On merits, you only have to pass the order.
Yes, madam.
Kindly be seated.
Yes.
Petitioner claims to have served in public service during the period 13/12/1983 and 1/5/2001. First off, counsel for the petitioner submits that though the petitioner has retired after rendering the qualifying period of service for pension and other terminal benefits, because of some disputes not connected with the petitioner, the same have not been settled, despite giving a representation dated 3/5/2025, a copy whereof avails at Annexure A5. First up, he also tells the court that pension is not a bounty, but is a matter of right, wide DS Nakara versus Union of India, 1982 Supreme Court.
83, man.
83. 82, 83. It is reported in both. Give that page number. Sorry. Next paragraph.
Page 130.
AR 82 SC 130. Next paragraph. Learned ASC on request accepting notice for the opposite parties very fairly submits that he would instruct his clients to look into the grievance of the petitioner as has been aired in the subject representation in a time-bound way and in accordance with law, should all the contentions of the parties be kept open. First off, with this proposal for the petitioner is also equitable. First off, next paragraph. In the above circumstances, petition is disposed of. One sign for compliance, including so and so is 8 weeks. Open to solicit. Now no costs.
Item 37.
Those matters.
Yes.
The petitioner was appointed Shiksha Sayak in 2012 matter.
2012.
His service are regularized by opposite party along with others
dated 7 under annexure.
Why terminated?
No notice on termination. They have issued a so-called notice that you have submitted fake OTT certificate.
Fake?
Fake OTT. Odisha teacher exhibition certificate.
Eligibility.
Certificate.
Fake it is.
That they says, I have submitted reply, it is not fake, and I have directly requested to submit to supply documents based on which charges have been framed. Thereafter, I find after the termination, I approached my lord. During pendency of the case, they have issued and without any inquiry, without following the provision under Rule 15 of the CCA rules, straight to issue order of dismissal, that is Annexure 6, page 29.
Where no inquiry, nothing.
Nothing.
I have to take it to the list that improved order has been issued in 2023, my lord.
Correct. December 2023.
Yes, ma'am.
Now he is without job. You are saying it's a fake certificate. He says it's a genuine certificate. Should you not hold the inquiry when he is very breadwinning, he is at the stake?
Yes, ma'am.
For withholding increment also you have to hear. But if you take out the job, you need not hear him at all. Issue emergent notice. Learned ASC accepts notice for the respondents. Returnable within 3 weeks. Post after 4 weeks.
Item 38.
Yes. Yes, brother.
My lord, I may be permitted to remove the defect.
Permitted to
Remove the defect, my lord.
office defects.
Defect pointed out by SR.
Yes.
Shall be removed.
Petitioner to address the office objections within 2 weeks. Okay.
Item 39.
Yes. Call after 4 weeks.
Item 40.
The liquidates filed, my lord, but late on 6/8, only accepted.
40.
Yes, item 40.
Okay. Yes, Mr. Das. What is that?
The postal liquidates for issuance of notice to the respondent 3 is filed late.
Late.
That is on 6/8. Can be accepted.
Requisites furnished should be processed.
Okay.
Okay. Immediately. Next. 41.
Item 41.
I have filed a memo to withdraw the IA application number 10107 of
Petitioner has moved a memo seeking withdrawal of IA.
IA, my lord, because
Withdrawal
due
of
to some clerical
IA number
13107 of 2025.
13107 of 2025. First memo accepted and application is disposed of.
My lord, I will file a better IA, my lord, by
With
tomorrow.
liberty to file appropriate application afresh.
My lord, the status quo should be maintained till next.
It's there already.
Yes, my lord.
Interim order to continue for a period of 4 weeks.
My lord, my short date be given, my lord, for the final hearing.
Now you have interim order, na?
Yes, my lord. But
Is it 41, sir?
41 years.
This 41, but the instruction itself is the order. Because 91 proceeding was initiated on his complaint. That somebody has constructed the house of the party without permission under the Odisha Development Authority Act. So 91 proceeding was initiated.
What is that?
91 proceeding, if unauthorized construction is there without plan or anything, so that should be.
That proceeding is going on.
No, proceeding was initiated.
Against him? No, against third party.
Upon his complaint.
On his complaint.
Yes,
Proceeding already closed.
Just a minute. That proceeding was dropped for the reason that the petitioner himself has filed a civil suit.
Don't drop, my lord.
Just a minute. Why simultaneously? You have not say. Let him allow me.
Yes.
What is the fact I am stating?
Drop language stuff.
That was closed. Closed. Why closed? Because it was found that the complainant himself is a plaintiff in a suit and claiming for the title over the land
and land is recorded in name of somebody else. And that is also multiple title is involved, the challenging that. So in view of that, it could not be concluded that the person against whom the proceeding was initiated, that should be demolished or removed or whatever that be. Whatever consequential order will come. Against that, there is a provision for appeal under section 91(2) of the Orissa Development Authorities Act. So that appeal was before the government. But the government also confirmed the appeal, confirmed the order of the ODA court, said that in view of this disputed fact, everything is there. He himself is a plaintiff in a suit. That is why this is also dismissed. Appeal dismissed. So this is the scenario of the case. So what can we do, man?
What do you say?
Today, my lord, today
You have filed a suit, civil suit.
civil suit is pending.
Yeah, you seek order at the hands of the civil court.
One dead man will be kind.
No date will be given.
My lord,
What is there for giving the date? If there is reasonable prayer, I will give you.
My lord,
Where is the question? Now there is a title suit.
Civil suit is not barred, madam, in this case, because
Kindly look into this. All the prayers which you have made against the said authority, you can claim because of that Bai versus State of MP, 1969 Supreme Court. All those prayers are available to you. I will permit you to make appropriate application before the civil suit and you process it.
my prayer matter, civil suit at the time of civil suit was without appearing both the parties, the civil suit was dismissed.
Civil suit was not dismissed.
At the time. Thereafter, my client filed a
Restoration.
restoration petition.
Restored.
Restoration petition, my opposite parties, 2-3 months back, he was
Your opposite, not municipal.
opposite parties, 4 and 5.
Defendants in that suit.
Opposite 4 and 5 appearing for before 4 or 5 months. Before when the opposite parties are appearing, the case was closed. The case was closed before the OD Act.
Correct.
OD Act
Section 91.
91.
And you filed appeal against that. Appeal also 91(2). Appeal also came to be.
Without approval of plan, the construction was made. I have given a complaint. The opposite parties are made.
Who are you?
I am my forefather's property.
Who said you are fighting the legal suit now? It is your claim that you are the one.
Suit was when suit was dismissed before I have given going to the OD.
That makes no sense now. Where is the locus standi? Dismissing the petition. Otherwise,
given a 2 passover, my senior is coming.
You have argued all now and now you want to be senior.
My senior is coming. He clarify all. 2-3. My only time. 2-3.
What 2-3? You have argued. He argued. You argued. More Palki wala here. Yes, you have argued everything now. Right down.
My only submission.
Commissioner is knocking at the doors of
only 2-3
assailing the orders of the OP number.
My lord, one passover.
One at OP number.
My lord, the petitioner was kindly see, my lord.
So post OP number given of the Orissa OP 1 and 2.
Appellate authority is 1. 2 is the
OP number.
My only submission, my lord, the opposite parties. Number 1.
government.
Opposite one of government, opposite one to UC court. I have make 2 complaint petition.
Who are you? You are nobody with the property till your suit is decided.
Because my it is my forefather's property.
That's your case before the civil court.
Civil court, my lord, is pending, and they are continuing construction.
You will get the building also if you win in the suit.
Well, can you see the before this case, another case was already filed. Bearing number.
Now, all right, another what we should do. This case is pending for
in
title.
this case, I have filed under section 29 of the OD Act for
for 29 of the old act, I am filed for inquiry. For inquiry of who is the legal heir of the property. But they are the opposite part number.
They need not look into that now. Because your suit is pending.
सूट नहीं सूट मतलब सॉरी सूट इज पेंडिंग सूट सूट हैव नथिंग एल्स सूट इज ओनरशिप बिकॉज़ दे आर
No prayer to that effect also in the records. No prayer to that.
In the suit, you have prayed for titles, declaration of title.
Blank slip page 9, madam.
Why are you
Page 7.
You are unkind to the judge, not only to your friend. You are unkind to the court. I am saying your suit is pending.
No, page 7, para 9, madam. That the petition humbly submitted here that the opposite part number 1 and
you go and bring your senior immediately, so that I will get relief from you.
I have matter in other court.
You have said no. I have noted. Don't.
My friend.
Yes, your friend. Let her be here.
Next one.
Password. Yes.
Item 42.
I am for OP number 2.
OP number 2. One is appellate authority, 2 is the original authority.
Appellate authority in the government.
That is 1. 91-2.
And other party that I am. Other 2 and
Private. 2. Private.
Alert. Item 42.
Number?
Item number 42.
What's 42?
Madam.
Yes.
There is noting that the requisite has not been submitted.
Requisite not submitted.
Not submitted.
You want to submit now?
Submit within a period of 2 days.
Submitted to submit within 3 working days.
Madam. 43 is also similar.
Same.
Okay.
44.
Item 45.
45, madam, your last name kindly see order dated 8/8/2025, madam.
8/8/25.
8/8/25, madam.
What it says?
That order, my lord, directed
The
the,
element.
my lord.
Whether officer has come here. The meanwhile, the additional opposite parties are directed to undertake the test and come out with the reports on Tuesday. And AAC is directed to convey the gist of this order to jurisdictional authority. Did they conduct the test?
No, my lord.
They are not conducted.
No, my lord. Even I tried my level best to download a copy of your lordship order and handed over to the competent authority for a compliance of this order. They denied it, my lord, saying that the case was posted to today, my lord.
Yes. Where is your officer?
Sir, not formal notification said the instruction by lot.
Give that copy to him. Why direct instruction is one thing.
Yes, my lord.
Maybe my order is wrong, but wrong order is nevertheless an order.
Not order is not wrong, my lord. Instruction.
Have you done comply with this test? Since a person suffering pending matter request consideration and war footing regard being had to the enormity of the disease, call this matter 25. Learned AAC is to be ready to so and so merit on merits. And in the meanwhile, the jurisdictional opposite parties are directed to undertake the test and come out with the reports on Tuesday.
They take it twice in a week, my lord. See the subject cited above in a reference to a letter number such and such. But the superintendent, my lord, written to the concerned department, my lord, I have examined the patient, Mr. such and such, in OPD. He was undergoing it twice weekly hemodialysis in the Department of Nephrology and came for second transplant and advised to register at SOTTO, that is, my lord, state, that is state organ and tissue transplantation organization, my lord. Or
No, he refused to receive the court order.
yes, no, my lord, that. Lord, we have communicated.
You communicated.
My lord. Why
You communicated the order.
Yes, my lord. With the order, my lord. I have communicated to words.
How many kilometers away that officer is from the court?
4 to 5 minutes. 4 to 5 teams.
5 kilometers.
5 kilometers.
Ask him to be here by 2.
Like tomorrow, my lord? Tomorrow, my lord?
Today at 2 p.m. There is a direction to conduct a test It may be wrong direction.
No, no, they
He cannot sit in appeal over the High Court judge's order. He can file appeal is another thing. This order he has not complied with. Is his case.
We'll call it.
The kidney patient.
Yes, ma'am.
Suppose if somebody was such a patient in his house, what he would have done?
Well, they have provided treatment and he is advised to approach the state.
What
appeal.
advice to approach? We asked him to do a particular thing that he has not done. So ask him to be here.
Yes, ma'am.
Call him.
And my lord, so far the noting is concerned that notice was not issued to the private operating party number 4, my lord. Already filed the requisite, my lord.
You have filed no, that's all right. In anyway,
Yes.
Now this you look into his version also.
Yes, yes.
I have provided the copy.
Whether that,
Given the copy.
that helps you,
No, my lord.
that will not help.
No, because I want kidney of the unrelated person, my lord. And the test is required for that purpose. What they stated, my lord, that the kidney of a deceased, my lord. Proceeding will find, my lord, in that instruction, my lord.
The kidneys will be alive for some period even after a person breathes his last.
My lord, with due apology, my lord, there is a committee.
Yes.
You have to face the committee.
Conducting test, I will face the committee, my lord.
But will you go today for
Yes.
treatment?
Yes.
Go there, we are instructing them to.
I'm talking over telephone.
Yes, you tell because
Yeah, I will take care of
he
it.
is assuring.
Yes, yes.
What else is required? If learned government advocate says,
Yes.
that should suffice.
Yes, yes, my lord.
Yes, that's good thing.
The submission may be recorded, my lord. I am
No, no, not necessary. I am committing.
Yes,
He
yes.
said
That is
that
wrong.
we will ensure.
Yes, yes, yes.
There is no reason to doubt the government advocate. He represents state.
My lord.
We'll call this matter at tomorrow. In the meanwhile, he will say what has happened.
Yes.
Here. Call tomorrow. All right, go there.
Item 46.
By any amount of argument,
My lord.
kidney will not become all right. For that, some medicine, medical treatment has
yes,
to happen.
it has to be.
Yes,
May I please your lordship?
yes.
No challenges the order under Annexure 1, notice to show cause for cancellation of the plot with the allegation that petitioner has availed that plot under discretionary quota.
You have availed it under discretionary quota.
But the fact is that
Today, my lord, they sought the copy of the amended copy of the reputation. I received it, but fact remains, my lord, so far discretionary quota. I've gone through that just now. The single discretionary quota, Hon'Ble High Court said that it should be released. So there is a direction of the government or the resolution of the department that all these should be released subject to compliance of other conditions. They must not be having other plots and all this. I'm doing that, my lord, maybe taken up some other day so that it can be disposed of.
That's very fair. We call this matter on 21st at the request of the net senior panel counsel appearing for the OP, answering OP. Okay.
Item 47.
interim order to confirm.
Till then, interim order to continue. Yes.
47, my lord. We are against the state, my lord.
47.
My lord. My lord, I'll just give a brief, my lord, because there are huge orders of this honorable court, which has laid down what the matter is about, and already directions have been issued. My lord, the case in crux is I was a contractor who got a job.
My lords, I have instruction that the order passed by my lords in order dated 24/4/2025 has already been complied with. There was a direction to refund the security deposit made by the petitioner.
You have refunded.
We have disbursed. And other things, my lords, being a contractual matters and disputed facts regarding escalation and other things cannot be adjudicated in a writ petition. They have to take shelter of
Direction
arbitration.
is to refund.
No, my lord, what was there was.
Where is the direction?
No, my lord, may I kindly have order number 7, order dated 24/4/2025. Order number 7, my lord.
Released immediately once they provide the details of the plan.
My lord, before that, may I only read out from para 2, my lord?
After the approval of the higher authority.
Para 2.
Yes, I have read that.
Learned counsel for the state submits that by way of an additional affidavit, opposite party admit that the security deposit against the present petitioner shall be released. The other component of the outstanding amount payable to the petitioner shall be released only after approval of the higher authorities. That was stated on affidavit. However, learned counsel for the petitioner submits that petitioner shall provide all the details. He further contends the security deposit supposed to have been released in 2014 also bears some interest component which the opposite party is not agreeing to. Since it is a security deposit and the deposit should have been released in the year 2014, so learned counsel for the state should take instruction about the interest component. In the meantime, learned counsel for the state shall make sincere effort in releasing the amount due to the petitioner, including the interest component, which is the other components, my lord.
Yeah.
Now, my lord, if I may only state, my lord, it is not a disputed question of fact. It is my case that it is admitted. If I fail before your lordship that it is not an admitted question of fact, then I accept, my lord.
Now you take that money first.
That has been received, my lord.
That has been received.
The security deposit without the interest has been received by me. Pursuant to this order. This order, there was another order that you give your PAN card that I also gave. After that, the interest, security deposit without interest have been received by me. My lord, now there are other two issues which they have admitted in the counter. So it is a case, otherwise, my lord, I would not have bothered your lordship in this constitutional setup, my lord, that I can't reduce your lordships to a recovery proceeding, my lord. But it is a case where it is admitted. So I've got judgments of the Honorable Supreme Court, my lord, latest from our High Courts, where it says that it's admitted. My lord, may kindly, for a moment, my lord, my lord, may kindly have the count where it is accepted, admitted dues.
Brother, all right, 1 second. Well, you were supposed to refund that in 2014.
My lords.
How many years you have retained?
My lords, what I humbly submit, because of the dispute raised by the petitioner, my lords, fact is like this, my lords. He had undertaken 2 works. In one work, he has completed the work. In another work, that was rescinded by because of the non-progress and other things. There was a liquidated damages of 4 crores and odd was imposed on him, my lords. He challenged that in an arbitration proceeding. In that process, this adjustment could not be made, and after settlement of issues in arbitration proceeding, we paid him the money.
The award also made in his favor.
No, my lord.
In the arbitration proceedings.
It was our counterclaim, and his claim was negative.
No, you are
my lords. What I humbly submit, my lords. In any way, my lords, he has to go to the fact-finding court, my lords.
The arbitration is in this regard also there is provision for arbitration.
Yes, my lord.
You have raised the arbitration.
No, ma'am.
You are not raised. There is arbitration.
Lord, may I only
now
state,
you have got 34 lakhs something, na?
my lord, if my case, if I have a right of first audience, no, my lord, it is true that I got 2 separate works.
One contract you have completed.
Two contracts, my lord, I got. One was completed, handed over. I raised the claim of 3 claims, my lord. One was that you refund my security deposit. Second, there was escalation cost. Both those were admitted contemporaneously. However, there was a decision by the government that because there is some issue in the other contract B, you will not release your contract A amount. I came challenging that order that you cannot club up to. There are 2 separate contracts. You cannot adjust an intra-contract thing. That is my prayer number 1 before your lordships. In the meantime, my lord, what happened? In the contract B, for which they claimed that you owe us money, so we will adjust it from here. That went to arbitration. Arbitration award was, please give me 1 crore rupees. The counterclaim was set off, and then 1 crore rupees
award came to be passed in
my favor. That was accepted by the state government. Payment was made to me. So that is a closed chapter. On the second contract, my lord, 1 crore rupees was paid, all on record. I'm not stating a single line out beyond the records. That was done. Now, my lord, was that because it is admitted contemporaneous in 2014, The only reason, well, because it was admitted, you said you will set it off. Otherwise, my lord, if they would have not have had anything to pay me, they would have said we will. There is no question of setting it off. So, my lord, now in their counter, they admit and say that yes, escalation cost is this much. Yes, security amount is this much. Obviously, interest part they did not admit because I am asking for a claim. Now, they before this court, they filed an affidavit and made a statement that, my lord, we are giving the security deposit. However, the other issues we have already, they handed over a letter to your lordships, after which the 24 order was passed, saying that they have already sent it to the higher authorities for clearance so that they can pay the amount.
For approval.
For approval of
that authority did.
Exactly. That is not my.
What is your authority did?
My lords,
Further Justice Panigrai's order says, subject to approval. Because whether approval is granted or
my lord's approval was granted for refunding the security deposit, my lords.
No, so far as security deposit refund is concerned, question of approval will not arise.
Exactly.
It is under the stakeholders.
My lord.
But approval is contemplated only in respect of other payment. Other component of the outstanding.
My lords, it was not. It was
after the approval of the higher authority.
It was not accorded, my lords.
He rejected it.
My lord.
Where is that? Show that.
My lords, rejection order I don't have, but we have sought for approval. It was not given, my lords.
Is it rejected? It
My
is
lord,
not given means it is not given till today. It may be given tomorrow.
your lordship may fix to another date. I will take instruction what has progressed.
Huh?
It is updated 1/7/2025.
Because the conduct of
My lords, now I got this information just now asking whether it has been complied or not. Anyway, my lords, this is a factual dispute.
But we don't agree with that. We don't agree with that.
My lords, admitted.
State
My lord.
you have already suffered an award for 1 crore rupees and rupees 35 lakh rupees order at the hands of this court. Where is the dispute for arbitrating?
My lords, unless there is a rejection, my lords, I got.
Therefore, merely because
My lord, it is fair.
it cannot be for sending matter to arbitration, there should be a dispute.
My lord.
If you say I will not cover,
My lords, in fact, my lords, the prayer is for a direction for final bill. Unless there is a final bill, my lords.
no. Anyway, there is some order passed now.
Yes, my lord.
Therefore, just look into that and come back. We will not send everybody to arbitration. State has to stand tall.
My lord.
And he has suffered an award for 1 crore rupees. You have suffered an order for 33,90,679, which you have given to him. In respect of other things, why approval is not taken?
My lord.
That you have to tell us on the next.
My lord.
Well, also
The
just
coordinate bench of this court-wide order dated 24/2025 at para 2 had said as such. Next paragraph. Learned AG appearing for the OP submits that in terms of the said order, already a sum of rupees 33,90,679 has been handed to the petitioner, and the counsel for the petitioner acknowledges the receipt thereof before this court. First of all. However, in respect of other component of the outstanding amount payable to the petitioner, comma, the approval has to be obtained at the hands of the higher authorities, as has been observed by the brother judge. First up, till date, approval, there is no information as to approval having been granted or denied. First up. Next paragraph. In the above circumstances, learned AG is granted a period of 2 weeks.
My lords, little more time.
4 weeks, are they? 4 weeks.
My lord.
4 weeks. To comply with the direction of the college.
The outcome of the approval.
Compliance, whatever it is. Compliance, that also can be compliance. Call this matter on in the second week of September 2025. All right.
Item 48.
Item 48 and 49 we can pass over, my lord.
Pass over?
My
Pass.
My lords, 48.
Ah,
I am not
ready.
ready.
20 matter, 5 years are over. You want which date?
Any date, my lords.
Call this matter in second week of September at the request of DG. Finally. Objections also not filed.
No, fine.
Okay. Next. Item 50.
49 lordship.
49 is urgent.
Pass.
49.
49 will pass over.
Pass over.
Okay.
My lord, on the 49 item, in court list, Dixit and P person consent P take the consent and remove the name of
My lords, we praise that name of Mr. Dixit Mahapatra to be and associates to be deleted.
Name of Sri Mahapatra to be deleted as requested. All right. Item 50. 49 pass over.
My lord, in that 49 he has prayed for deletion.
Pass over. Deletion in that. Item 50.
May I please, your lordship? And
Yes,
in this case, counter agenda, written note, dead set, everything has been filed, my lord. The petitioner, the husband of the petitioner, while serving, my lord, this is a school for the blind, are managed by under the Social Security and Empowerment persons with the disability department, my lord. SSCPD department.
Your absorption you are seeking.
My lord, my husband was serving as a cook in that school, and the school was granted a post, my lord, and he was died against that post. I have been appointed by the committee, my lord. And while I am serving as such, my lord, the government in the SSPD department has taken.
What is your prayer? I have not understood. Very clumsy submissions.
Now, my lord, the absorption of the petition.
Why you are here?
Since my post was not approved by the authority, my husband was serving as a cook, my lord, attended cook in that school, my lord. This is a school for the blind, my lord, blind children, under the Social Security and Empowerment Disability Department, my lord, SSPD department. And my lord, while after that, my death of my husband, I have been appointed.
Compassionate appointment.
I was given appointment by the committee, and I was serving since 2021, my lord.
4723.
My lord, 21.
21.
I was appointed, and I am continuing, my lord.
Where is that appointment order?
My lord, that document, my lord, that is. It is a school, my lord, Annexure 1, it is a NGO management school, my lord. And the government got they have got the grant, my lord, from the government, my lord. My lord, while the government in SSPD department has issued resolution letter to all the authorities for fill up the vacant post by the persons those are serving, my lord. Accordingly, the district authority has called for wrote letter to.
1 second, wait. What is his case?
My lords,
NGO. NGO is running that school. It is not the government.
NGO is running
NGO is running that school.
Government is not running that.
No. NGO is only for government is for some funds for all institutions. Yes.
Funds means aid. GIA.
Yeah. No. Only aid.
It's not GIA.
It's not GIA.
The GIA, my lord.
Huh?
GIA. They have
Where is that GIA order?
They have even in the counter also.
What is it? Somewhere
But additional district magistrate, this, that, etc. Many officials have signed
My lord,
We
all,
have also instructed the management to give engagement to the candidates only after obtaining authentication from concerned university.
My lords, in fact, there is a guidelines for appointments and approvals. As per the guidelines, he has to minimum complete 5 years of service as on 2023. He has worked for 2 years by then. That is why she was not qualified. It is not a case consideration. It is not a case of rehabilitation assistance
at all.
That is not applicable to this. That husband's service period will not be calculated towards
She did not, in order to get compassionate appointment, the deceased husband should have put in at least 5 years of service.
My lords, the rehabilitation assistance rules is not applicable to
them at all.
He is not, that is not his case in the entire petition, that it is a appointment under the rehabilitation assistance.
my lord, that is, my lord.
And my lords, our counter, para 6 and 7, we have specifically stated the reasons. Para 10, my lords, kindly see. Counter para 10.
In para 5 and 6 of the counter, your lordship, that is the detailed guideline. There is no such guideline of 5 years experience in the government letter.
You did not have any experience certificate.
My lord, that is, your lordship may see annexure B series, the government detailed guideline. The district authority has put that condition of 5 years. The government has stated that those are continuing in the experience, they should be absorbed against the vacant post. And the government has stated for the cook, the female should be appointed. And I was appointed by the committee, and I am a female, and the existing vacant post is there. My husband was serving since 2009 to 2021. After heart attack, he was died. Thereafter, I was given compassionate basis. After serving 12 years, my husband, your lordship may see, para 12, they have admitted in their counter affidavit that my husband was serving in 2009.
Para 12.
Para 12 of the counter affidavit. Sorry, para 13.
Para 13.
Para 13.
Para 12, the certificate verification was done on 24 by the subcommittee.
Para 13, my lord.
In 13, they say the rehabilitation assistance is not available.
Well,
There is no such instruction for extension of the benefits of rehabilitation assistance to the legal heirs of the deceased employees
My lord,
working in aided educational institutions.
my lord, in fact, my lord, that is a
para
absorption.
12, I am placing
That is the absorption of employees working on it. The other staffs have been absorption with the, but my case has not been, I am not, my lord.
You are
saying-
not completing even one sentence also. Complete the sentence with verb, noun, etc. Then I can understand. Otherwise, there was no need for me to go to other side at all.
My lord, since the management has appointed me in the year 2021, my lord, 2023.
You are appointed?
2021, my lord, after my husband's death.
Compassionate appointment.
My lord, the authority has considered by.
I'm asking.
Yes, my lord.
Appointment dated?
Dated, my lord. (25/1/2022). Sorry, 21 my husband died and 22.
25/1/2022.
22, my lord.
Then what you wanted?
My lord, while I am continuing, my lord, and our school, the government has decided to fill up the regular basis the staffs of the blind schools and the physically handicapped schools under the SSCPD department. The government has directed the district authority to call for the list from the concerned schools. 8 schools are the physical disability schools in the Baleshwar district. I am for the school for the blind. I was continuing, my lord. And then the district authority sent a letter to the collector and the school authority to sponsor the name in the vacancy position, my lord. My school authority has sponsored the names to the that these are the vacancy and these are the persons. None of the teachers are the regular basis. So for regular absorption, they have sent the proposal. And the authority, my lord, the district authority verified the documents and called for the petitioner and other staffs to attend for document verification and signing in the pro forma. We are all remain present. And then they have put, my lord, that for absorption, other staffs were absorbed on the regular basis in the school and they are getting the salary. My case was not considered, even though that verification was made on the ground that you have not completed 5 years experience. That 5 years experience was not in the government guideline for directing. This district authority has put at the 5 years experience.
Is it true whether the condition of 5-year experience you have put it?
My lord, selection committee, they formed regulations.
When did they form the regulation?
My lords, I am reading.
When they, if others are already absorbed, why you want to single out this place?
My lord, similarly not placed. They have completed 5 years.
No, where is the requirement of 5 years?
Yes, my lord. 6/6/2022 guidelines.
6/6/2022
guidelines. My lords, annexure H at page 24.
Page 24 of your SO.
My lords,
counter.
Yes, counter.
24, go to 24. What is, there are 2 more. This is 20 resolution.
My lord.
6/6/22.
My lord.
Who passed this resolution?
This is government resolution.
The government passed the resolution.
My lord.
The state government has notified rules governing them. Important education so disability is some for the government formulate a comprehensive statement for establishing the coordination matching institutions.
It is relating to establishment and recognition.
Education of persons with disabilities, government has decided to formulate comprehensive guidelines for the establishment of recognition institutions imparting education to children with the disability. The guidelines shall replace government resolution numbers showing the so when they are signed so. Where is the in this resolution? Where is the condition of 5 years?
My lord, 5 years not there.
Then,
but there shall be a selection committee under the chairmanship of collector of district.
no, your only ground why you have denied relief of absorption.
My lords,
she has no 5-year experience.
My lords, no certificate also.
No, where is the requirement? He says there is no prescription of 5-year service condition at all.
My lords, the committee empowered under the resolution, they have made the.
Where is that? Show that norm. Committee cannot be that arbitrary. Committee has to act on the norms. Every decision, Indira Nehru Gandhi says, every action of the government should be normative. It cannot be arbitrary. Whether others have been asking a question.
My lord,
Please hear the question first. Others who are similarly circumstanced like, are they absorbed in the service?
my lord, other staffs of the school, because only the attendant is a single post and it should be meant for the female. And I am the only candidate against existing vacancy. Your lordship, for a moment, page 15 of my writ petition, your lordship may see. Page 15.
You are not answering my question.
My lord.
Whether others, in other words, that question will not arise in your case.
My lord.
Because this is the only post which is vacant and earmarked for lady.
Lady and I am the only person.
Only person.
Continuing against that post.
Yes, brother, she has lost, she is a widow, lost her husband. Husband was also working with you. And now where should she go if you say that you will not absorb her? Your condition should be,
my lords,
human elements also have to enter.
My lords, may grant me some time. I will talk to the officers.
Call this matter for further hearing in the on 25. On 25.
My
look into just
my lords, if it can be done.
The government has to act with some sympathy.
My lord,
because
technicality should not.
Just look into that. There is a lady. Secondly, she is widow. Thirdly, her husband has already served in the institution. All these things will enter decision-making process. You cannot work like a machine. We are human beings. Yes. Item 51.
Please, your lordship.
Yes.
Not I am here to ventilate the grievance of a senior citizen widow who has been running for the last 3 years to get an allotment in our favor, allotment letter. The brief facts is such that her husband had purchased a plot in the year 2005 from CDA. There, the allotment was given to the husband of the petitioner. Now, after demise of the husband of the petitioner in the year 2012, she applied
Sir, you appear for the opponent.
Yes,
But
CDA.
Generally, he is very fair in such.
My lord, I would.
Anything can be done.
Yes, in fact, matters should have been done, but by the government matters, because we are acting upon the instruction of the government in the GA department. Matters kind of visualize one thing, the history matters, some history there matters to be explained matters for matters appreciation. What happened? So for BDA, CDA, BDA means Bhubaneswar Development Authority, Cuttack Development Authority, Housing Board, and General Administration Department.
They are formed under. Is there any Development Authorities Act?
Odisha Development Authority Act matters 1982, and the rule frame they are under 1983. These all were matters, earlier matters governed under the Town Planning and Improvement Trust Act. Subsequently, it was taken
That act is repealed and development act
taken up. That's these are pertinent. But that is not the point. Point is that they have developed various schemes, matters, the land allotment schemes. But fact remains there is an allegation that many of the plots have been allotted under discretionary quota of the chairman of the authority, and some of the people they got multiple allotments. That is what matters. Government decided to constitute a task force committee for inquiry into the matter. A task force was constituted under the chairmanship of ex-Additional Chief Secretary Mr. Taradat, already retired, and other 2 members also. They submitted a report. In the report, they have enclosed list of the allottees, those who have availed multiple allotments and discretionary allotments, and there are other list also, but we are not concerned on that now. But fact remains, that was placed before the cabinet, and the cabinet decided that yes, a resolution should pass, and all these multiple allotments and discretionary allotments should be cancelled.
So that is how GA department issued a notice. And secondly, my lord, the committee suggested that it is relating to a particular period, submitted that all that, because these are not exhaustive list, all that is there must be left, the committee special audit report should be there, and they should also ascertain whether any other person got escaped. Anyway, the task force report have come and submitted a report.
So, same fraud which appears, it appeared in Karnataka also. Same fraud.
Same type.
So, object is almost to allot one site for those who do not have sites.
But
It is
here in
not
this
to
case,
make rich.
here in this
Correct.
case, the same analogy.
No, here the difference arises.
I'm coming to your case, I can be of some help to you because it is not that
I'm grateful that he is always there. I believe to me as well.
the authority is not that I should see one, I should see the principle, so that at least all the cases in this light, standing in the same light, can be disposed of.
Correct.
But fact remains, what happened then? Then the GA department issued a circular that you issue show cause notice. Find out whether there is a discretionary allotment or not. So far, discretionary allotment is concerned, Mr. Honorable High Court in Navkumar Das, Mr. Navkumar Naik case said that, of course, I was a party to their matters. If it is a single discretionary allotment, they have not availed any other allotment, that should be released because they have paid the money. In this case, what happened, matters? Now I am coming to the present case. His husband, her husband, matters, got one plot allotted earlier. He sold the plot in a subsequent time. Now he purchased another plot from a third party, applying that, filing an affidavit to the extent that I have not possessed any plot.
No, but one he has sold.
He sold one plot.
What else is required?
But he sold one plot, but he sold the plot, but by the time he applied for the second plot, he was the owner of that plot. But he filed an affidavit stating therein that I don't have any plot. That is what my lord's last date, my lords, it was argued, and my lords wanted to that not here, my lords.
Which date we have put that case? Which date we have put that case? The other cases we have.
Other cases, my lords, September, so I think.
Give that date.
My lord,
Give
here
that
the issue is different.
Please tell me.
Okay, carry on.
It can be. It was before the Honorable Justice Raudra, my lords, Justice Raudra, after hearing the matter, required to see that affidavit. That is what I have come up with an affidavit, my lords. They see the affidavit, I will give a copy to that. Give you an affidavit. There, my lord, the only thing is that if he has one plot,
Which he has sold.
subsequently, my lords, by the time he applied,
He had no plot.
by the time he applied for the second plot to purchase, he filed an affidavit saying that he has no plot, but in fact he had the plot.
Which that plot he sold and bought another plot.
Another plot.
So that plot is equal. Bought plot is equivalent to allotted plot itself, because out of that money he has opted.
Yes, not that money. It was
Anyway,
thing is that my lords, he purchasing the suppose my lords, he purchased the 20,000, 30,000 rupees.
I'll look into what my case.
True.
Possible. 51. Officer is here. Let's see. Yes, 51. Take on 51. Then we can call the.
Item 49, my lord, rendered info, which was maybe
59.
Yes, that was possible. I was not.
Take that.
49.
59.
49. 49.
Just part of.
It is passed over. I filed it.
This board of bad times. As I
Okay. Yeah.
Item 41. Assumption. 41.
16.
Item 16.
Yes.
But at 41, your lordship wanted my presence for
41.
yes.
16 you said, huh? 16. Oh, both are same.
No.
16
my
different.
16. Here, petitioners are two brothers challenging the legal certificate issued by the revenue officer.
It's appealable order.
Appealable. I have conscious of the fact matter. You know, kindly see there are three certificates issued by the very same authority. And the issue has already been decided by the appellate authority. Like the instructions of private property, but not 2 and 3, 4 and 5. Kindly see annex of 3 page 31, madam. 31 is the first legal certificate issued by the revenue officer in favor of both the petitioner. They are the sons of the deceased Banamar Pradhan. And after that,
This is in respect of whom it is. Who died?
died my lord Banamar Pradhan. He is the father of the petitioner.
Father. Father is name?
Name Banamar Pradhan.
Banambar.
Madam. He died on 26/8/2011. Leaving behind my lord
26/8
to 26/8/2011. And there are three legal heirs of Banambar, two of the petitioner's son and one visually is the daughter of that Banambar.
He has no widow.
No.
Widow wife.
Visually is the daughter of the deceased employee, who is the father of the present petitioner. Deceased employee have three legal heirs.
Three legal heirs.
Two sons who are before the lordship, they are the petitioners. Another one visually Pradhan, who is sister of the present petitioner and daughter of the deceased employee, who died on 24/5/13, found issueless.
Two sons and one daughter.
One daughter, and daughter married and found issueless and died.
She also died.
Died on 2013. Date of death is my lord 24/5/2013. After the death of that father of the present petitioner, we applied for the legal certificate, and that after that is on kindly see annex 3, page 31.
Page 31.
My lord. Go to 31. Page 31, annex 3. The legal certificate issued by the revenue officer on 18/6/2020. Kindly mark the bottom of the date. Signature of the revenue officer. Date is 18/6/2020. Where only the present petitioner are the legal heirs, being the son of the deceased employee.
18/6/2020. Where she has shown only the sons.
Because the daughter already expired, having issueless. Annex 5, I challenge Annex 5 will also kindly see.
This is issued under which provision of law?
Of the miscellaneous certificate rule, my lord. Under the miscellaneous certificate rule 19.
You copy?
Yes.
Take that.
So that rule, my lord, will also kindly come to rule 3. Rule 3, Roman 2, deals with legal certificate.
Rule 3, Roman 2.
Deals with legal certificate.
These rules are made under which act?
That is miscellaneous.
Odisha missionary certificate rules.
No, that rules has been framed under which act?
Under which act these rules are promulgated?
The act.
Anybody in the court hall? Anybody knowing under which act these rules are promulgated?
Should I have a regulation?
No, it is earlier 84 rules are there. Thereafter 2017 rule was there. After repealing the 84 rules,
After that, 70 rules also repealed by virtue of introduction of 19 rules.
These rules are
Which act?
like proviso to Article 309. You will make rules. Mr. Mishra, these
certificate rules who act under the H.
kindly see that under which act these rules are made.
In fact, so far as this rule is concerned,
No statutory force.
no, it
309.
They are like executive instructions.
it's a subordinate legislation also, Your Lordship.
No, they are not made by legislature.
Madam. It's an executive instruction. That will be an appropriate thing. Because this is a resolution by the concerned department.
Whatever, name is different. It's only resolution.
It's an executive instruction, but that is governing the field.
Yes. Now one more certificate is issued.
Yes, two certificate. After issuing first certificate in favor of the petitioner,
Respect of same who is that Pradhan.
after
Banambara Pradhan.
Banambara Pradhan having two sons,
One daughter
expired.
Wife already predeceased. And daughter died in 2013. Correct.
Yes.
So only 2 persons remain.
2 person remain. After that, you also kindly mark Annexure 7 and Annexure 5, page 35. The very same revenue officer in 2023 issued another certificate wherein including the present petitioner, the name of 2 other persons who are claiming to be the grandson of the deceased employee.
Grandsons are also heirs only.
But they are claiming they are the son of Bijuli, the daughter who expired. But fact remain.
No, grandson and they have mentioned grandson. And are they not grandchildren?
No. That is my entire case.
No, he will decide.
Yes, that is a very same authority. Also kindly see one document. That very revenue officer already issued a letter to the appellate authority. That is, my lord. Kindly see page 30. Page 30.
Page 0.
My lord. That is on dated 30th September 11, 2021. The Tahsildar issued a letter to the sub-collector, who is the appellate authority. Also kindly see, when inviting a reference to the letter on the subject cited above, I am to submit here that legal status of late Banambara Pradhan, son of late so-and-so, is in favor of the kind and person election. Further, it is to intimate that Bijuli Pradhan, daughter of Banambara Pradhan, is dead and found issueless. If the authority, revenue officer, said that Bijuli is dead, issueless, then how 2023 he has given a certificate mentioning that 2 sons as grandson? And thereafter, I filed an objection to before the revenue officer. Now, latest, kindly see Annexure 7.
Another is issued.
Another is issued.
What he says?
So in that case, a certificate out of 4, only 3 are remain, including the present petitioner. Out of 2 grandsons, only 1 grandson name is there. Page 39.
Who appears for the government?
Yes, said.
Yes. What for the heirship certificates are used?
Used for, that is also mentioned in the rule,
For what purpose?
That is the
Inheritance.
Inheritance of property.
Yes, page 5, rule 5 of that rule doesn't mention. Rule 5.2, legal certificates shall be granted for drawal of pension, gratuity, area of salary, provident fund, receipt of government assistance, ex gratia payment, withdrawal of money from financial institution, post offices, registration of document relating to transfer of land and building, change of name in case of utility services, basic amenities like electricity connection, LPG, etc.
Yes, what do you say? On what basis he has issued all inconsistent certificates?
Notices of
Notice was issued.
No, first time.
When a DG is requested to issue notice, DG is requested to accept.
I have filed an IML, Annexure 5 and 7, 2 successive certificates.
Are they parties here now?
Yes. I am crossing my notice to the private party 4 and 5 to rest.
Emergent notice to 4 and 5. An application supported by affidavit is moved seeking stay of certificates at annexures
5 and 7.
5 and 6.
5 and 7.
5 and 7.
Dated, my lord, dated 6/12/2023 and 22/7/2025.
Respectively dated
6/12/2023 and 22/7/2025.
item 22/7/2025. First up, learned counsel for the petitioner submits that when already inquiry having taken place, the heirship certificate dated
18/6/2020.
18/6/2020.
Annexure 3.
And annexure A3 has been annexure 3 has already been having been granted, comma. The other two impugned certificates that are inconsistent with the contents of the certificate A3 would not have been issued. First one. Some courts in this submission prima facie. First, next paragraph. In view of the above, application having been favored, there shall be stay of certificates at annexures A5 and A7. A7. Till next date of hearing. Item 41, keep rules also along with that.
In fact, 41 I'll place. In my friend's matter also, where the amount is huge and there is a disputed claim, there is need of succession certificate. This legal heir certificate will not do.
Correct.
Yes.
So there is no substitute for succession certificate at all.
Exactly, Your Lordship. So there it has to be a succession. But this,
But I am wondering,
yes,
how these kind of rules can be made in the form of executive inspection without legislation.
Yes, well, I just I'll further find out, but as it appears, apparently there is no
it does not
legislative sanction to this rule. It may be at best a executive instruction, which has been given in the shape of a rule, like miscellaneous, Your Lordship has seen mutation manual. Mutation is a compilation of instructions, executive instructions.
Of the revenue department.
Yes, but that's written 1, 2, 3, 4 like this, and 111, we say there is a provision of revision in 111. These are all executive instructions, but this is compiled to term as mutation manual. Whereas the statutory force is Survey Settlement Act and Survey Settlement Rules. But these are all instructions providing procedural modalities to be done while carrying out the objective of the Act and rules. It's like that. Lordship, I'll find out if there is anything further, I'll definitely.
In Ram Javaya versus State of Punjab, Justice B.K. Mukherjee's judgment, the executive power of the state is coextensive with the legislative power. Where there is no legislation occupying the field, executive instructions can be issued, provided that those instructions should not touch the rights of private citizens. These are all touching the rights of private citizens.
That is what the problem is.
Anyway, they are not put in charge.
May I please, Your Lordship?
Yes.
The item 41, my lord.
Yes.
Here an application was filed which was found to be defective. So therefore,
Application for
my lord, a police cell for the reason there was an order of status quo by the Hon'Ble Court. And that order of status quo, despite the order of status quo, construction was being carried out. And despite report to the police, to the competent authorities under the Development Authority Act, action was not taken. So that for that purpose, the IA was filed, which was listed today on being mentioned. That IA was found to be my engaging advocate to be defective. He wanted to withdraw it, so for the main application is not concerned, the IA for filing a fresh application. Now, on the basis of submission made by Lannis Senior appearing for the opposite party, Your Lordship was asking the maintenance of the proceeding. Let me just explain that. But because on the ground of pendency of a civil suit.
Civil suit is for title.
Now, let me just clarify that.
Is it true or not?
The civil suit, he was saying it is for partition, but in the order it is mentioned for title.
Yes.
Partition is also a title of the declaration of share.
Correct.
So in terms of section 34 of the specific requirement. Despite that, let me just make a distinction. What is the distinction between Orissa Development Authority Act and the civil suit, section 9 of the CPC, the right of infringement of a civil right? But these two applications out of which these repetition RHS were filed with regard to the construction they carried out without any approval of plan, zero approval for plan. That is a deviation of plan approved and without a plan are two different things. I beg to submit. Now there is a dispute with regard to the ownership. I am not disputing, a civil suit is pending. For the limited purpose of finding out as to whether action should be taken or not, these authorities under the Orissa Development Authority Act have been clogged with power under Section 29, read with Section Rule 33 of the Orissa Development Rule to inquire into the ownership. In fact,
Ownership also.
disputed ownership, they can do, there is a power. To what extent they can do, that's a different thing. An application under 29, Section 29, read with Rule 33 was filed before the authority. That was not taken care of. The original proceeding was dismissed. Appeal was preferred. Appeal has been dismissed simply saying that a civil suit is pending without examining whether the statutory power available to the authority, original authority, in terms of the statute, their creature of statute, has been at all exercised or not. And that is why
The sections.
that is why the Honorable Court entertained the writ petition and issued notice and granted a protection with regard to construction.
You're not correct.
Well, I am saying only that was not done.
Apex Court said in a number of decisions,
Yeah.
the local body authorities shall not inquire into title disputes
Your Lordship.
if suit is already filed. You have already filed the suit. Partition suit is a title suit.
I'll just say one thing. The distinction is with regard to the construction. There is a claim of ownership in the civil code. I am not disputing that. But your Lordship says, will it denude the authorities under the Orissa Development Authority Act to inquire into a construction which is done diverse any plan at all? So that is where I beg to make a distinction.
I understand. If you had, as a person who is residing in the street, you are entitled to say they are constructing in violation of the.
It will come in a PIL. That will not come there.
Well, no, even otherwise.
Yes.
Now, you have structured your complaint on the premise that you happen to be the owner of the property.
Yes.
Because it has come from his grandfather.
And that is what 29 springs into action.
Now that 29 stands excluded because of your suit.
I'll humbly submit for the limited purpose of prima facie deciding as to whether an action should be taken or not.
Wait.
And one more thing I will to point out a development which my friend says, the suit has been dismissed for default.
Get
And
it restored. You will make an application and application will be considered very leniently for restoration.
The Lordship may sit there. That will do also.
But that helps you.
How again sitting there?
Shorn of the pleadings and the accompanying document by way of annexures, the essential dispute relates to title to the property in question, in respect of which some construction is said to have been undertaken without obtaining the approval of building plan to the scene. First off. Next paragraph. Learned senior advocate appearing for the petitioner vehemently argues that notwithstanding pendency of a civil suit or partition and separate possession of the property in question, there is a statutory duty saddled on the OPs under the provisions of Orissa Development
Authority Act.
Development Authorities Act 1982. And therefore, that public duty, at least on demand, needs to be exercised. First off, that having not been exercised properly, learned counsel submits, interference of this court is warranted. First, he also submits that, adds that the subject civil suit having been dismissed for non-prosecution, an application is moved
or restoration, and it is at the evidence based.
Restoration, and the said application is being summarily tried before consent. First one. Next paragraph. Learned panel counsel appearing for the OP numbers 2 and 3, 1 and 2. OP numbers 1 and 2. 1 is government, 2 is authority.
Your Lordship may say 3 also, because Cuttack Municipal 1, 2 and 3. Panel counsel is for 2 and 3.
Counsels for appearing for 2 and 3.
1 state.
And learned AGA appearing for the first respondent opposes the petition, contending that where the complaint of the kind is structured on the premise of ownership, and that a title suit in that regard is being brought, ordinarily the statutory authorities do not venture deciding the title, whatever be the extent of power availing under the provisions of this Act. Kindly be seated. They also point out that the OP number 2 and 3 passed an order under section 91(1) of the Act that came to be affirmed by the first respondent government in appeal in exercise of power under section 91(2) of the Act. First, they add that a deeper examination of the matter is not warranted regard being had to the pending suit, in respect of which an application for restoration of the dismissed suit is being tried. First, this stand is agreeable to this court. First, next paragraph. In the above circumstances, this petition is disposed of, reserving liberty to the petitioner to process the application for the restoration of the suit before the jurisdictional court. Suit in OS number, what is the CS number?
I'll just give that.
CS number. So I need it. First of all, it hardly needs to be stated that the summary dismissal of title suit for non-prosecution is not desirable, and therefore ordinarily the courts favor the request for restoration of such suits on compliances and conditions. First of all contentions are kept open for being urged in the suit.
Only I was praying, Lordship will be kindly observing that I'll move the interim petition also there. That much, if your Lordship pleases, man.
First of all, if any interim application is moved in the application seeking restoration of the suit, the jurisdictional court shall address the same in accordance with law after hearing all the stakeholders in the matter. In that connection, no opinion is expressed.
Civil suit number 159 of 2009.
CS number
159 of 2009. I'm so grateful. Urgent copy to the
web copy to be actually. Yes, grateful. Yes.
Item 51. Wait, please, madam. But before coming to my subject,
Yes.
I was listening. Your Lordship was querying about the existence, the enactment which has followed, which is followed by Odisha miscellaneous rules. Here, the Google says in 82, the government of Odisha did not pass any specific enactments or the rules related to a miscellaneous certificate, as it's a standalone topic. However, the broader framework for issuing various certificates, including those related to revenue and other administrative matters, was governed by existing rules and procedures within the Odisha Treasury Code.
Odisha Treasury Code.
Yes.
That again is not a legislation.
That is a derivative from the Government of India Act, what my learned senior sister says, 1935.
Chairman said that.
Yes.
1935 Act.
1935.
Government of India Act 1935.
Government of India Act 1935, but subsequently amended after Constitution came into office.
But there is one decision of the Apex Court where it said it was, of course, it related to PWD code, where such a contention was taken. Apex Court did not agree with that. That is State of Mysore versus Fernandez. You can see from the Google. Can anybody Google out that decision? State of Mysore versus CG.
Here also they further will say
Such codes are executive instructions.
And executive.
Appears to be executive instructions.
Yes.
1960s edition, 66, 67.
67.
Huh?
1967.
They are 67 Supreme Court. Okay, is there?
Yes.
Okay. This is the decision. Anyway, just look.
My lord. My lord, in this case, the petitioner applied for a certificate, the allotment letter on basis of succession because the husband died. Husband was issued with the allotment.
One question.
My lord.
You were allotted a site. Your husband was allotted a site. He sold it. From that money, perhaps other money also, he bought another site. Okay. Then he had applied for allotment of the site.
Yes.
If already you have availed one site,
Yes.
which you had sold and the proceeds you will retain, it is as good as you are owning the site only.
Here the question of allotment, what the CDA says that it is multiple allotment. My case is that it is not coming within the fold of allotment itself. It is a third party purchase. It is a transfer. So whether allotment encompasses transfer as well is to be looked into.
Of course, transfer will not be.
Yes, transfer should not come within multiple allotment. And the task force which was formed to see whether how many people were benefited from multiple allotment have given a report and have particularly prescribed what amounts to an allotment. That is there in the allotment, the task force report. So if I come within the allotment, then definitely my case will fall under the allotment and I will not be issued, or even if I have been issued, that will be resumed, or the necessary actions will follow. But here is a third party transfer that has never been prohibited by any authority. And your lordship must see. Yes, that is a third party transfer. I have purchased from another allottee by way of an agreement to sell, and they have allowed.
You have bought that property.
Yes, my lord.
It's not a case of allotment at all.
Right, my lord.
Because it is given to X. X is selling it to Y.
Yes.
That is the case.
Yes.
And now what happened?
Now they have rejected my application for issuance of allotment letter to me on succession basis, basing upon the task force report which says that multiple allotment should not be allowed. That is their whole case. And they have come out with another case that I have.
Your allottee had availed already other side.
My
son with whom you are now your vendor.
My lord.
Was he allowed multiple sites?
No, that is not their case. That is not their case.
Let us see.
Sir. It's kind of a today's affidavit. Let us be very fair.
Yes, sir.
Appreciate about the actual fact.
What has happened? Now he is saying his is not a case of allotment at all. They want to buy from the allottee.
Exactly, some commitment.
We are asking now whether that allottee had the multiple allotment or not.
No.
Then you have to give that.
That is not the case at all. Fact is that, my lords, it's a kind of
Let us go to your prayer.
My lord.
Plot number 7D, so and so CDA Katak in the name of the petitioner.
Yes,
It should be transferred in your name.
yes.
Why who should transfer that?
That the CD authorities is to transfer
Who
because
is the owner of the site?
the CD.
CD is the owner.
Yes. What is done by the CDA is they lease out the property
To
to various persons in manner. It was allotted in the name of my vendor, this property.
your vendor.
Yes.
Sir.
It was allotted on which day to your vendor?
In 1996.
No man. One Mira Sahu, the original allottee that the plot under dispute matters. One Mira Sahu is the original allottee of that plot number 7D/1301 on 5/9/97.
Mira Sahu is allotee.
Allottee.
Srimati Mira Sahu.
Yes.
Thereafter,
Allotment letter
allotment letter number I am not given, but
dated
allotment letter
Dated is they have given in the affidavit itself.
that
4/4/1996. That we
496.
I'll just put in here. Well,
Just I will ascertain the foundational facts I want to know.
Yes, the
Because
fact-
I have to give justice to you.
my lord, Mira Sahu has transferred it in the name of one Vijay Sahu who happens to be the husband
Transferred means how?
by way of permission from the CDA. That allotment was transferred. That is there in the affidavit itself. That is not disputed by them.
Slowly, one by sentence, then let me pause between sentences.
My lord.
Original allotee is Mira Sahu.
Yes.
Mira Sahu, whether allotment is negotiable under the scheme of the act. If
Yes.
it is allotted to me, can I sell it to Y?
Yes.
Allotment letter itself I can sell, or after obtaining a property I can sell.
After obtaining the property,
Whether she obtained the property
yes.
by sale deed was executed.
The lease deed between CDA and the Mira Sahu is executed. I think that is there. But I have.
Lease is dated. Is it lease come sale
No, it is a lease
Lease.
deed. It is a lease deed.
for a period of?
That is 99 years, my lord.
Lease is dated.
Lease is dated. My lord.
Is it
5/7/1997. Yes, I have the document.
5/7?
It's not lease deed, man. These are all provisional allotment letter and final allotment letter.
Yes, final
Lease deed I have not
allotment
yet
letter is to
Whether
be.
it is registered under the Transfer of Property Act. Every lease requires registration.
Yes, my lord. That put
Under 17(1) of the Registration Act.
That is what the last
section 100 and,
Yes, that is what last date milers directly. If you say that yes, this has been registered, kindly produce that registration deed.
That's what.
This is the lease of my vendor. So that is
in the
96.
lease.
My lord, the lease is not with
May I
me.
submit my
The provisional allotment is with
Allotment
me.
is there.
Yes, which says upon execution of the lease deed and possession, you will be entitled to sell, and that lease deed will be executed upon final payment of the premium.
Yes. Whether Mira Sahu made the final payment,
Yes, my lord.
on which date she made the, is it true? Whether Mira Sahu, do you agree that allotment was made in favor of Mira
Mira
Sahu?
Sahu, there is no dispute.
And 1 second. Whether Mira Sahu got the lease deed?
No,
No lease.
no. It is a fact remains, my lords.
It was only allotment.
It was an allotment. She was handed over possession. She remained in possession. Thereafter, she applied for a transfer on broad transfer basis to substitute the allottee. It is a concept of substitution of the allottee. His husband came to his step. His husband. He wanted to see that this property should come to husband. The allotment should come to his husband.
Mira's husband.
Husband. Mira's husband. Vijay.
The name?
Vijay Sahu.
Vijay Sahu.
But the provisional allotment letter says that if you want prepossession transfer, if you want to transfer the property, you have to take permission and NOC from the CDA. So he took permission and he transferred it out, but that transfer was effected on 18/5/2000.
In favor of Vijay.
Vijay.
18/5/2000.
Then Vijay Sahu submitted another application. Also, lease deed has not been executed in the favor of Vijay Sahu.
Okay. Very allotment letters on the basis.
Only on the basis of that.
Everybody
Only
is
substituting one allottee and also choosing, the only option left is that the allottee who has been allotted the plot is to choose another allottee. And that option is available with them. But that allotment will be allowed and they will be treated as an allottee subject to compliance of the permission matters from the authority. Also means CDA matters. Here in this case, Meera Vijay Sahu applied for transfer of the plot in favor of Nandkishore Namanda.
So everybody is dealing with the property which is not with them.
Not with them, not with
Only
the
allotment letter.
allotment letter.
Whether allotment letter is negotiable.
Well, here in this case, that was also a subject matter of dispute insofar that task force report is concerned. That is what the task force expressed the concern. It should not have been.
Because Apex Court say from Maharashtra matter
Yes.
that allotment of sites under the statutory schemes are not negotiable unless the section itself provides for the contrary.
Right. Right, man. That is the proposition throughout minors.
Because it will be like succession is under section 6 of the Transfer of Property.
Transfer Property Act. Special that will go into that.
Yeah.
But now minors, I'm not entering into all this because things has happened minors. 2005, he applied to get the land transferred in favor of Nandakishore Mandal. And the CDA also allowed the same.
It allowed it.
Allowed this
In favor of Nandakishore Mandal.
But while allowing, the requirement is that this person concerned who will be the vendee, means allottee, will be substituted as an allottee, means like Nandakishore.
He is Mandal's vendee.
No, he's not, he's
Mandal's wife. Mandal's wife.
Mandal died.
Oh, widow.
Mandal's widow. So, Mandal, we require that the only right is that suppose the plot is allotted to me. I wanted to transfer to change it to him. Then both of us should file affidavit indicating therein the second man who will purchase that doesn't possess any other plot allotted by CDA.
It's a precondition.
It's a precondition. It has to file an affidavit.
Who Meera Sahu has to file affidavit?
No, Nandakishore is to file affidavit.
Nandakishore.
Nandakishore, because he has to get that plot.
One who is going to have the plot, he himself has to do.
He has to do it. Because the option left is that it should have been put into auction or put into lottery. Instead, they have been given an option. They may choose a person.
If they don't have any other site.
But subject to condition, if they will not have any other site, then no, they will be entitled to.
Site
the whole objective
in which, in Orissa.
So, but that development authority is
the limits of development authority.
That scheme developed by development authority. So, for Cuttack is concerned, two schemes are developed. One is at Shikarpur housing scheme, another is Vidanasi housing project, commonly known as CDA.
Whether this widow has got any other site?
No, widow has not got any other site.
No, sir.
Nandakishore, what Nandakishore did is, Nandakishore way back matters in the year 1994 applied for a plot directly.
Was he allotted?
He was allotted a plot 8 by 773.
Then what happened to that?
Then what happened? He sold the plot. He sold in the sense he transferred the plot in favor of a third party. That is, he got a transfer matters. So he got one plot. Once you transfer that property to third party, and then you are filing an affidavit
that you don't have a plot.
It's a fraud. And consequently, it was taken as if you are availing a multiple allotment. This is the reason for which the Nandakishore died, the wife is suffering. And that is what I have given in sequence. Well, kind of a glance that my today's affidavit, that will clarify the thing. It's not a question of transfer, only substitution of allotted to allotted.
Now my case is, my lord.
Let me
that he has given a false affidavit.
My lord, sir. That affidavit is page 6, my lords. D by 2. That clause 3, clause 4 and clause 5.
He was
allotted. He should have said that yes,
I was allotted, but I sold it.
I sold it. Had it been disclosed,
I would not have allotted it.
I could not have allotted it.
could not have allowed that colloquial language transfer, could not have also allowed transfer or substituted, allowed substitution.
The object is that the property of the state should be distributed. Is under Article 39 B and C. That is the object.
Yes. So usually the concept of utility.
That's what the of Benthamite
concept of maximum happiness to the maximum number of people. And the professor, according to Professor Bakshi Miller's, maximum possible number of persons.
That was incorporated in directive principles of state policy.
But in B and C.
Yes, but there has to be, my question is, my lord, this false affidavit, if at all.
Coming to that matter,
there means two questions which has to be answered by them. Whether there is any provision in the original deed, or there is any provision under the act, or is it the task force only which says there is a provision? There is no provision anywhere.
That is how I will impose one now. Otherwise, others will not get the site only. Everybody will have bunch of sites.
Others should be different.
People will not get it.
Suppose I will be allowed to purchase property on third party transfer. If I can get one, I can also get another one. So one will be getting 10 and other 9 will be awaiting, my lord.
That rationality, my lord.
Justice will be affected.
Here he had purchased, the petitioner's husband had purchased a plot, very small piece of plot. For the extra need, they had a bigger family. After 10 years, they wanted to purchase a bigger plot. And the CDA with the premium allowed them. But there was only one plot then. So whether in need of a bigger plot, can a citizen not purchase that? Well, I pose that question to myself, my lord. Yes.
From whom?
From another party, third party, not from the CDA at all. From
third party, you go to market and buy any number of plots. Who says no?
My lord, but here the question is, the CDA's prohibition, embargo, is on the allotment. That a person cannot be given to allot. If I am asking for allotment, that is prohibited. I cannot get 2 plots under any.
You are claiming under Nanda Kishore.
Yes, my lord.
Nanda Kishore had already got allotment and he had sold one.
My lord.
Therefore, Nemo that quad non-habit will come to your against you. Nanda Kishore could not have got another plot at all.
While in existence of another
plot. Existence means that plot is there. He sold it to XYZ. He getted the money. Money is another form of plot. Money is another form of plot. Because with that money he can buy another plot.
Correct, man.
Therefore, what single advocate saying makes sense.
Correct, man. The object he is saying that it is like the allotment. Now, your lordship may see the Supreme Court has taken care of this in another decision where, yes, my lord. That copy I have already given, my lord. What your lordship may be having it. That is 1971 pre-Supreme Court cases 708. District Council of United Khasi and Jantia Hills and others, etc. versus Miss Sitimon Savian and etc.
What is?
It says this the matter came up before the Supreme Court relating to an allotment, which prohibited that the areas, the plots in that area cannot be allotted to any outsider. There, the Supreme Court said, yes, it cannot be allotted, but anybody who wants to sell it to an outsider can sell. That is transfer, and allotment does not encompass transfer within its meaning.
That's right.
So here is a similar case, my lord.
The Supreme Court referred to Section 5 of the Transfer of Property Act, perhaps in that decision. Kindly see that.
My lord.
Because Section 5 of the Transfer of Property Act defines what is transfer. One cannot transfer. Allotment does not come within the ambit of transfer because it is statutory. Allotment of the kind is statutory.
Correct, ma'am.
Statutory transfers, statutory purchases like compulsory acquisition, land acquisition, etc. are outside the definition of transfer.
Grateful, my lord.
Kindly see, I'm not sure.
No, Section 5 has not been quoted, but here the object of the enactment vis-a-vis the words of the enactment was, my lord, construed.
But now the point is, here, Nanda Kishore had already bought one property, allotted one property.
My lord.
He could not have got the property in respect of which now you are putting the claim forward.
Yes, my lord. Now, your lordship, that vital document which they rely on is the task force report.
Correct.
That is there in the counter affidavit. Your lordship may see.
Yes. He has said, I do not possess any land, building, flat, either in the name of family members within so and so project area or accommodation. Because he had already sold. On that ground, he is saying this.
No.
He is a liar on the verge of the truth.
My lord, this may be construed otherwise. By the time he purchased, he had already one plot. I am conceding. By the time this affidavit was filed, he was already in possession of the plot which he sold afterwards. So, my lord, this affidavit now is of no consequence in as much as my lord, limited understanding is there, because this affidavit was not to be filed. This is a format which the CDA is imposing on everybody
He has
who
agreed
is
with that.
applying.
He has agreed to that.
Yes, he has agreed in the year 2005.
Yeah.
Now it has been like 20 years which has passed.
But
that's a different aspect. Equity, my lord. That's a different equity, because the widow,
you cannot widow, all right.
one plot is there. Only now, as the matter stands, it is only one plot she is in position. There are no two plots. It was sold in the year 2009.
Money is with him. One who had suppose if I get one plot and I sell that plot and pocket money, can I say I do not have plot at all? No, you have converted it into money.
To that extent, it is not correct. This affidavit is not correct. But it was thrusted upon him because he could not have purchased them.
Who knows? He should have said that. You cannot say.
And your lordship, because why this affidavit is coming into picture is because of the task force report.
Correct.
The task force report says, my lord, your lordship may see in the counter affidavit, the modalities of allotment. If these are the allotment.
Anyway, he got the allotment on the basis of an affidavit which is not true. His untruth will cast its shadow on his claimant. Under whom? Because you are claiming under him. You are claiming under him.
Right, my lord.
Therefore, his falsity will cast a shadow on you as a widow.
After having known that he has the plot, the CDA has issued succession certificate. I mean the allotment letter. That your lordship may see. This is what the multiple allotment, what annexure B/2 they are, my lord, relying upon.
Yeah.
At page 10, annexure C/2. This is the report which the task force has given. So annexure C/2 through the counter filed by CDA, page 10. If the basis of acquiring of the land falls within this category, then it is allotment, and those lands cannot be issued with allotment letter, and that is available for reservation.
Yeah.
So this is the 45 clause recommendations. The VDA, CDA, OSHB have not maintained the presented important documents that files, minutes of proceedings, lotteries, auctions, allotments, including under discretionary quota, for more exact scrutiny by the task force. Nevertheless, it is apparent that one or more of the following methods have been followed in making allotments across the schemes and projects at issue. So these are the methods which they have enumerated. This is one: allotment by lottery, allotment by auction, allotment under discretionary quota, allotment on first come first served basis, allotment on by online payment or payment in limited installments, allotment on case-to-case basis described as normal allotment, or allotment by other means but has disguised effect of expanding the discretionary quota, application-based allotments made on the ground that the units available for allotment were more than the applications received, allotment made by one of the method against a unit upon surrender by the original allottee is not necessarily the method of its subsequent allotment. So these are the category of allotments. If a person has been allotted a plot within this category, then it is to be treated as allotment, and subsequent allotment under this category is multiple allotment. So there is a provision embargo on a person having two plots under such method.
Yes.
The third party transfer, my lord, they have not mentioned anything regarding the third party allotment in the task force. So here I cannot overcome the false affidavit which is there. That is correct. But whether that affidavit will have the consequence of,
But for this affidavit, they would not have allotted any site to Nanda Kishore at all.
That is exactly, my lord.
I'll point out only small one sentence. I'm not disturbed.
I have understood the case now.
Only thing, my lord, I point out.
You can go on arguing, but no problem.
No, well, that what fell from your lordship, they could not have allotted. They could not have allotted on the basis of false affidavit, but they have not allotted. They have just taken the premium for a subsequent transfer, which is permissible in the lease deed itself. The lease deed prescribes that one party can transfer to the other party.
Lease deed is not executed.
That is, my lord, their procedure is they have to get a conveyance deed. That is there in your lordship may see. It is there in the allotment letter, my lord.
Nothing.
One point, last point, it has occurred to your lordships at page 14. That you will not be entitled to transfer the plot by way of sale or mortgage, etc., or otherwise, part with possession of the whole or part without the previous consent in writing. The authority reserves the right to refuse or give consent, it's absolute, and in the event of the transfer mortgage or otherwise.
Post conveyance.
Yes.
That condition comes post conveyance. We have not traveled to that level at all. We are on the entitlement of Mr. Nanda Kishore himself. We do not agree that he is entitled to. We agree with the Cabinet Council whether there is a rule or not. That I will read into the scheme itself. You are not entitled to. We are not entitled to have. Otherwise, we are 140 crore people in the country. So only few are holding the entire wealth of the country. What should happen to other people? That is the object with which Dr. Ambedkar ji enacted Article 49, 39B and C. Kindly see that, give that the Constitution. B and C are so beautifully structured in our Constitution. They enact the distributive justice. The resources of the state shall not be in the hands of chosen few. That is the object. There is one famous judgment also. I don't remember 39, 39. Give the Constitution. B and C. In fact, Sirvai has so beautifully discussed that aspect of the matter.
Sirvai will not be here.
B and C is discussed in Sanjeev Kaul versus Union of India. 83 Supreme Court, the Justice Chinnapareddy's judgment. You cannot have that way. That is the object. Otherwise, only few persons only rich people will become rich and poor people will remain poor. That's not the object of the Constitution. Distributive justice is one of the facets of our Constitution. That is the reason why land sealing, you cannot own more than so many acres of land because
land selling is
they should reach to people.
My lord, 71 Supreme Court also took that object that Assam that the tribe should not.
That is Jantia Hill case.
Yes.
Jantia Hill has many special laws. There are many aspects. We cannot take it as the gospel because Jantia Hill, right from the days of that Queen versus Burra, it is treated by Queen versus Burra that Jantia Hill is governed by traditional law. There are such judgment, the federal court judgment, if I am right. Take out that Queen versus Burra. Queen versus Burra, B-U-R-R-A-H. That is decided already.
Yes. My lord, there also in the Supreme Court.
Anyway, can we read Article 3 and C?
Yes. 39. Certain principles of policy to be followed in the state. The state in particular direct its policy towards securing that
read it slowly.
Yes.
The state shall.
That the citizens, men and women equally have the right to an adequate means of livelihood. B, that the ownership and control of the material resources of the community are so distributed as best to subserve the common good.
Common good, common community, not individuals.
My lord.
Therefore, that has to be ready to these with the schemes now.
Yes, my lord, but here is a case who has purchased a smaller plot and wanted to have a bigger.
Reasons to follow. Yes.
My lords, I am only relying upon one decision, my lords, in support of my lords, that filing false affidavit does not give a right to claim any benefit.
That's what.
That is New Okhla Industrial Development by Professor Ravinder Kumar Singhvi. I got it, my lords, online.
Then your judgment also you give that. Yes, my lord. Petition dismissed on the following grounds. Firstly, the allotment of the sites in question is kindly be seated. Is a matter of statutory policy evolved under the provisions of Orissa Development Authorities Act 1982, and therefore the provisions of Article 39B and C of the Constitution, directive principles have to be read into, consistent with the object with which they have been enacted. First off. Number two, the original allotment letter was issued to one Srimati Meera Sahu on 4/4/1996. Kindly correct me if dates are wrong. Okay. First off.
5/10/1997. 5/9/1997.
5/9/1997. 97. Then she transferred it to in favor of Vijay Sahu, her husband,
On
18/5/2000. Vijay Sahu transferred this right to allotment in favor of Nanda Kishore, surname Mandar, who is none other than the deceased husband of the petitioner, widow. First, petitioner widow seeks allotment and conveyance under the said allotment, contending that whatever allotment was made in favor of her husband, would create interest in her favor, not as an allottee, but as a transferee. First term. This is bit difficult to countenance. Everything is being treated under the principle of spes successionis enacted in Section 6 of the Transfer of Property Act, in as much as the property in question is in nobody's hands. The same remaining with the statutory body. First of all, this court is not very sure that there can be transfer of spes successionis in the light of Section 6 prohibition. Next point. Learned panel counsel appearing for the OPs is right in telling the court that Mr. Nanda Kumar Mandal was granted allotment because of his affidavit to the effect that he did not own any other site within the jurisdictional area as on the date he had applied for such a transfer of allotment. First one. However, the affidavit is crafted in the verge of truth, inasmuch as he had already one allotment and he had sold it to another, keeping the sale proceeds into pocket. First off, such cases also fall within the normative idea of allotment, consistent with the very state policy. First off, this view gains support from the Apex Court decision in New Oak Law Industrial Development versus Ravindra Kumar. Is it Apex Court? Yes, but this citation you don't have, at least neutral citation. In Civil Appeal number 382 of 2012. Just look into this. Just one. Next paragraph. The vehement submission of learned counsel appearing for the petitioner that there was no legal sanctity for the, so far as the requirement of filing the affidavit is concerned, and that even otherwise, the idea of allotment or multiple allotments are treated in the government resolution dated 30 January 2015, into which the transaction in question would not fit, and therefore there should be no impediment for granting of relief is difficult to countenance. First off, what one has to see is not just what has been enumerated in the resolution, but also the pith and substance, the intent and content, policy content of the said resolution. Viewed from that angle, the allotment in question would not have been made in favor of Nanda Kishore, but for his false affidavit, and therefore, under the principle of nemo dat quod non habet, his widow cannot seek the benefit, derive any benefit under the allotment in question. Petition dismissed. I'll refer to petition of Apex Court in which brother, which you put it to give that 19th. Could you get that Queen versus Burra?
Queen versus yes, sir. It is 19.
Which year?
1877.
1877?
The Empress versus Burra.
Empress versus Burra, 1877?
26th March 1877.
No, citation. Just write down that citation. That I missed this. Refer to District Council of United Khasi and Jantia Hills versus Miss Sidimon Sawain. Along with that. Yes. Yes, sir.
She may not be dispossessed from the only plot she has. Now they will take action for disposition.
Yes, that's the object. Otherwise you withdraw the petition, then question will not arise at all.
I seek that liberty.
You file the memo instead of losing the site also. File the memo at least. Sir, he wants to withdraw the petition. Let him withdraw. Because she has come here not to get the injury salted. Let her have the injury, but will not salt the injury. You file memo.
Any members who are losing a good job.
Recall that order. Counsel for the petitioner, having argued the matter for some time, seeks leave of the court to withdraw the petition so that he will pursue his remedies elsewhere. But ordered accordingly, a petition which is put off. Well, right, that's the, you say that we want to pursue remedy elsewhere. Nice. Yeah. Find the memo, memory itself.
But the yesterday's matter, that lecturer group A scale and reader state scale. But I have prepared a date chart also, date chart with written note of submission.
Yeah.
Well, in order
Serial number?
Serial number 52.
62.
But in order to refresh your lordship's memory.
No, that you were saying.
Yes.
Rule.
The placement rules of 2014.
14 rule, sub rule 3.
Yes.
B. 1B.
Yes.
1B.
Yes. My lord, may kindly turn to annexure 8.
8 years plus 9 years.
8 years plus 9 years. It comes to 17 years. After completion of 17 years from the date of approval of my date of joining, I am entitled to get lecturer group A scale, and 10 years thereafter, I am entitled to get reader state scale. And what are the requirements? Your lordship may kindly see that rules, annexure 8, because in my written note, I have also annexed one circular of the state government.
Where is your written note?
My lord, I have given. Deliberate.
Pakistan.
Deliberate, sir. Deliberate.
It is stitched already.
Yes. But there is a clarificatory. Your lordship may kindly see the placement rules first. That is annexure 8 at page 33. Annexure 8 at page 33.
Page 33.
33. I am claiming benefit under this.
Give the petition for.
Your lordship may kindly see the nomenclature of that rules. That is 1-1. These rules may be called the Orissa non-government aided colleges.
Page number?
Page number 33. Annexure 8. My lord got it. Yes.
Page number 33.
Yes. Well, yes. The nomenclature of that rules is, these rules may be called the Orissa non-government aided college lecturers placement rules 2014. Then your lordship may kindly see 1-3. They shall come into force with
date of publication.
With effect from the first day of January 2014. Not from the date of publication. That is 1-1-2014. 1-1-2014.
That is the section 1-3.
That is section 1-3. Rule 1-3.
Rule 1-3.
Rule 1-3. Then your lordship may kindly see rule 3. Next page, page 34. To whom that rule is applicable. Applicability. These
non-government aided colleges.
These rules shall apply to the junior lecturers
who are in that pay scale and pay band.
Yes. Your lordship may kindly see. These rules shall apply to the junior lecturers / lecturers in non-government aided colleges who are in the pay scale of 9,300-34,800 with grade pay of 4,600 under ORSP, Orissa Revised Scale of Pay Rules 2008, before commencement of these rules. That means prior to 1-1-2014,
correct,
he must be getting that scale and grade pay.
Yeah.
Well, then you have 4B. In order to be eligible for placement to the grade of lecturer group A scale of pay under Rule 9, you also may skip over A.
4-1B.
B.
completed at least 8 years of service from the date of receiving a full grantee in the post of lecturer in case of appointment by the management. Here I have been given appointment by the management. It is an old aided college.
Whether was it receiving the full aid?
Full aid.
Before your appointment?
Yes, yes. Before my appointment, it was getting full aid from 85-86. And then your Lordship may kindly see the explanation, because Rule 41B has to be read with explanation. For the purpose of Clause B and Clause C of this rule, the expression full grantee shall mean completion of 9 years of continuous service from his/her approved date of joining. My approved date of joining is 1/8/1993. That is under Annexure 3 at page 70.
1893.
1/8/93. Well, the approval order was passed on 17/10. That is under Annexure 3 at page 17. Serial number 3.
Page 30, page number?
Page 17, 17. Loknath Behra, lecturer in mathematics, post held first, date of joining is 1/8/93.
Number 3.
Number 3. Date of joining is 1/8/93. This is the approval order. And by virtue of this approval order, I got granted. Then, my lord, so from the date of my approval, 9 years is to be counted. To get full granted, 9 year comes to 1/8/2002. 1/8/93 plus 9 years. It comes to 1/8/2002.
1/8/2002.
Then plus 8 years as per rule 41B. Which comes to 1/8/2010.
Where have you structured your ground in accordance with?
In my written note. In my written note, I have given everything. Of course, I have given in the writ petition also, but in the written note, I have given everything. Then your Lordship may kindly see what scale I was getting prior to 1/1/2014. My Lord may kindly see, because that is the dispute here. Your Lordship may kindly come to Annexure 4 at page 20. When I got full salary cost or 100% of pay, my Lord may kindly see that I got initially granted as per the granted order of 2009. That is my first approval order.
Yes.
My Lord, the granted order of 2009 had undergone an amendment in 2013, page 20, Annexure 4.
22 February.
Yes. 2nd February 2013, but it was published in the official gazette on 28th February 2013. My Lord may kindly see Rule 1(3).
On the date of publication.
On the date of publication of the Odisha Gazette, on the date of its publication in the Odisha Gazette. That means from February 28, 2013, it will be effective. Then your Lordship may kindly see the amended rules, Rule 2, that has been substituted. The teaching and non-teaching employees of the aided educational institutions under Para 4 of Granted Order 2009 shall be paid granted in the following manner. A. The eligible employees of these colleges shall be paid 100% of pay at the initial rate plus grade pay in the revised scale of pay of ORSP Rules 2008. My Lord, so far as ORSP Rules 2008 is concerned, my Lord, I have given in my written note that ORSP rules, that very resolution of the Finance Department. My Lord, kindly see that. Kindly come to page 12 of my written note. That resolution dated 16 December 2008, that is ORSP Rules 2008 was
issued by the Finance Department. My Lord, may kindly see the last page of that resolution. That is Annexure 1 appended to that resolution at page 21. Previously, my pay
6,500.
6,000. I was getting pre-revised scale, that is 6,500 to 10,500. Now corresponding revised scale is 9,300 to 34,800.
4,600.
Grade pay. I got that grade pay in accordance with the amended rules of 2013, Annexure 5 series. It starts from page 22. My Lord, may kindly come to page 23. Serial number 3, Lokanath Behra. My pay was fixed in the scale of pay of 9,300 to 34,000 and odd, with grade pay of 4,600. Your Lordship may kindly see the last but one column. As per the amended order of 2013, I got it from 28 February 2013. At the top.
In which your petition?
Petition. Page 23. Annexure 5 series, serial number 3. My name finds place at serial number 3. Lokanath Behra, lecturer in mathematics. My Lord, may kindly see, my pay was fixed, basic pay 9,300 at particular scale. Then grade pay is 4,600 and other things are there. And then your Lordship may kindly look at the last but one column. It was made available to me from 28 February 2013. Because that amended rules of 2000, amended granting order of 2000.
Date of publication.
Date of publication. It will be more clear if your Lordships will come to page 25. The Department of Higher Education Department's own letter. That is letter dated 18/6/2020. My Lord, I'm the first paragraph. The drawing and disbursing officer, DDO of Gop College, Gop District, Puri, is hereby authorized for drawal and disbursement of monthly salary in respect of following 2 staff of junior wing. I am in junior wing, junior college. And 2 staff of degree wing of the institution under direct payment scheme at the rate as detailed below. My name finds place at serial number 1. Scale of pay 9,300 to 34,800 with grade pay of 4,600. As per approval order, that remarks is there.
Then you are a member of cadre or not, that question you have answered yesterday.
Yes, I have already answered.
There is a decision also.
Amit Kumar Patnaik, in my written note I have given. And another judgment, even if, because they argued that initially I got the block grant, but in fact I have not got the block grant. I got the pre-revised scale. If your Lordships will look at the 2009 granting aid order, my Lord may kindly see the granting aid order of 2009. It will be made clear. Page 399 of that book.
You have not produced it along with this your statement.
Well, it is available in the education manual. I have given the amended order, but so far as 2009 order, by virtue of which I initially got the granting aid, that is available in the manual.
Page number
399. Well, this granting aid order was framed to provide granting aid to all left out employees of aided colleges. Your Lordship, may kindly see Rule 3. Rule 3. Eligible educational institutions. Employees of teaching and non-teaching categories of the following educational institutions notified as aided educational institutions under Clause B and 3 of the Act who have not received granting aid or block grant shall only be eligible for consideration for receiving block grant for its employees if they have been appointed in accordance with the yardstick and other things are there. And different category of aided colleges have been mentioned in A, B, C, D, E and F. And your Lordship may kindly see, so far as my college is concerned,
that is at page 403, Annexure A. List of 255 non-government aided junior colleges received 98 prior to 94. My lord, may kindly come.
Your institution comes here.
Yes, that name is there. My lord, may kindly come to page 410. So far as my college is concerned, it is located in Puri district. Page serial number 220, Puri. Page 410. Gop Junior College, Gop. And now your lordship, may kindly see, my lord, Rule 5, rate and disbursement of block grant. Page 101. Page 401. My lord, got it?
401.
Yes, of the manual.
Yeah.
Rate and disbursement of block grant. The block grant payable to the employees of aided educational institution under para 4 shall be a fixed sum of grantee rate which shall be determined by taking into account the initial of the basic pay at the pre-revised time scale of pay, 7 increments plus dearness allowance at the rate of 41% as on first day of January 2004.
The teaching and non-teaching stuff.
Yes. So I got my salary that is in the pre-revised scale of pay. That is
No, why all that is necessary?
that is not necessary. Well, and my last judgment, which I have not given to your lordships yesterday, that I have given, even if in case of grant institution, because 2 pleas they have taken in the counter affidavit that I am not included in the cadre. I have shown the judgment of your lordships of the coordinate page.
Automatic
entry into the cadre. Then my second plank of submission is, so far as direct payments system is concerned, this letter itself shows at page 25 that I am under the direct payment scheme. Page 25, government's letter.
Institution.
Well, may kindly see that government order dated 18/6/2020. The drawing and disbursing officer of Gop College, Gop District, Puri is hereby authorized for drawing and disbursement of monthly salary in respect of following 2 staffs of junior wing and 2 staffs of degree wing of the institution under direct payment scheme at the rate as detailed below.
They themselves have said that.
They themselves have said. And in the block grant case also, in that pension case, it has been held. That is page 94 of that judgment. Hemant Chotrai judgment.
6.1.
Well, at para 6.1.
What they have said?
My lord. Well, at 6.1, your lordship may kindly come to page 95. The word direct payment system has also not been defined in any of the granted rate order.
Anyway, direct payment, they themselves have said.
They themselves have said, and
18/6/2020.
Yes. This is my case.
So they cannot say that you are not under
the direct payment scheme. Only 2 pleas have been taken. One that I have not included in the common cadre. Since
cadre is automatic.
Automatic since I have received granted rate that much.
Yes, what is it?
I have also prepared a comprehensive synopsis and data
Give that.
for your lordship.
What's it on? What are the grounds on which you have denied the relief?
First ground is
A, B, C, D.
Yes, ma'am.
Come
the first ground is your lordship may kindly come to Annexure 8. My learned friend has placed before your lordship, page 33.
Annexure 8. Now we'll go to that rejection order.
Rejection
Go to
order.
the rejection order.
Yes.
Because you have taken particular grounds there.
Yes.
You have to sustain them. That's all. Nothing more, nothing less.
Before that, may I place my detract? It will be half.
Very, very, in a way you want.
Yes.
Yes.
The on 27/1993.
Appointed.
Yes, the petitioner was appointed against one post of lecturer math by governing body and joined on 1/8. Having not been completed of qualifying period of service of 5 years by 1/6/94 was found ineligible to come under the benefit of GIA 1994. What happened in the meantime, my lord? When he failed to get the block grant under the 94 block grant in aid order, he approached the state education tribunal. And he got an order in his favor. Thereafter, the state filed a FAO before this Hon'Ble Court. And in the FAO, the state succeeded in FAO. Then the petitioner went to the Hon'Ble Supreme Court. And in this Hon'Ble Supreme Court, he lost the case. That is our civil appeal number 725.
That related to what?
Granted order approval. Granted order
Claimed granted as per the granted order of 94. That chapter is closed.
No. Yes.
He got granted as per 2009 order.
Please, that had some relation. That's why I brought your lordship. Then your lordship may kindly come to next date. That is on 17/2/2010. His appointment was approved. My land's friend just now before lordship told that his appointment has been approved from 1/8/93. Here, your lordship will see his appointment was approved as per GI order 2009 in terms of Odisha aided college, aided junior college and aided higher secondary school GI order 2009, and he was allowed to avail block grant with effect from 1/2/2009. First, he got the block grant from 1/2/2009. Then second, then next, 22/2/2013. GI order 2009 was amended by notification in 2013. Accordingly, the petitioner got 100% block grant in initial rate plus grade pay as per ORSP rule 2008. Then 1/1/14, again quantum of block grant was revised by the GIA Amendment Order 2014 with effect from 1/1/24 and paid initial pay plus grade pay with 5 increments as per ORSP rules 2008. 1/1/2017, GIA Amendment Order 2017 came into force and the petitioner was allowed to receive full grant in aid in shape of block grant with effect from 1/1/2018. 1/1/22. At present, under Odisha payment of GIA to non-government aided degree college, junior colleges and higher secondary schools, GIA Order 23, the petitioner was allowed to revise the salaries in the form of block grant. Accordingly, the revised pay as made applicable to the petitioner as per GIA Amendment Order 2013 or 2014 or 2017 or 2023 are in the shape of block grants, not under direct payment system.
But you have said under direct payment, under the direct payment scheme only.
Yes, only for the purpose of what I have taken the instruction of not in writing oral instruction today I contacted, that is for the sake of treasury, to draw the money they have written. Then your lordship, I will come to 1970 rule I'll place your lordship. What is direct payment? Odisha education, recruitment, conditions of service.
Page number?
Page, your lordship, come to 982.
Yes.
Chapter 3, middle. You got it. Rule 9. Left side.
Yes. Drawal of.
Yes. Drawal of pay and allowances by employees of aided institutions. Every employee of an aided educational institution shall draw the same pay, dearness allowance, and subsistence allowance in case of suspension as is admissible to counterpart in the government educational institutions under the relevant rules. Counterpart in the government educational institutions under the relevant rules applicable to him and shall ordinarily be paid in the month following 1 month to which the claim relates directly by government or by any officer or by any agency authorized by the government. So first, my demonstration before your lordship is, first there should be equal at par with the government employees. First. Then it should have directly paid to the employee concerned. Then in this connection, your lordship, I have brought one decision of the then Honorable Chief Justice Mr. B.L. Hansaria. Your lordship, I am giving David. No. Your lordship, kindly.
What was the issue considered?
That is regarding direct payment scheme.
You mean to say petitioner is not under the direct payment scheme at all?
Yes. Throughout till 23, he is in program.
What is difference between these two? Direct the block grant and the grant in aid. Block grant in aid, it is also grant in aid.
Not full grant in there. Not full grant in there. Taking the conditions, the economic condition of the state, first they were getting 40%, then 60%, then 100%. It is not like a government employee, those in government schools. That is my. Then your lordship, I am giving paragraph 5. Honorable Justice, these and the Chief Justice, Honorable Hansaria.
Can you share a copy of the judgment? I don't have that.
Yes.
I'll just read it and then pass.
Yes, I'll pass. এটা হচ্ছে পাত্র স্বরূপ The 1970 portion of the paragraph 5. 1976 amendment to which we have referred earlier, however, leaves no manner of doubt in our mind that a school which is fully aided, as is one of at hand, has to be regarded as one under the direct payment system of which mention has been made in Rule 3 of the rules.
If it is block grant, it will not be fully aided. Unless fully aided, all these benefits cannot be claimed is your content.
Yes. Then your lordship, then now I will come to take your lordship.
Give that copy of it.
I'll give it.
Because I'll note
Then your lordship.
This is of 1993.
Yes.
Subsequently, any rule is amended?
Yes.
There is amendment of the rules. Which amendment?
Well, Section 7C came into force in 1994. And under Section
This
7C.
judgment is before amendment.
Yes.
Section 7 of the Orissa.
Section
Education-
7C of the Orissa Education Act, it was incorporated by way of amendment in 1994. And the concept of block grant was introduced in 1994 by framing different grantinate orders under Section 764. Your Lordship, may kindly see that.
Page number?
Page number, my Lord, 137. This was framed in, my Lord,
This judgment is before amendment.
before amendment. By referring to Rule 9 of the 1974 rules.
Rule 7.
7C. Your Lordship, may kindly see. Because,
That liquidates this judgment.
yes, and that has been taken note of in that pension case also, Patra Sorang. Your Lordship, may kindly see the bunch which I have given in my written note, case 51, para 2.15. My written note. Patra Sorang versus State of Orissa, 93 2LR, page 272 has been taken note of. That is prior to amendment of incorporation of Section 7C.
Have they so declared this judgment? Have they considered this judgment?
Yes.
What they have said about this?
Well, Your Lordship, may kindly come to page 51 of my written note.
One of your written note.
Yes. The judgment of, what is it? Hemant Chotre.
So for Hemant Chotra case is concerned, my lord,
That is
a sub judice. The writ appeal has been filed.
Writ appeal
and
has
matter
been
was
filed.
before the division bench of this honorable yesterday, and that has been fixed to 15th September.
Yes.
So he cannot take.
No interim order has been passed. No
He
interim order
cannot
has been
take
passed.
of that.
No interim order has been passed. Your Lordship, may kindly see para 2.15. Okay. Para 2.15. It is also contended that prior to introduction of grantinate order 94, this court in the case of Patra Sorang versus State of Odisha and others, 93 2LR, page 272, in para 3, while interpreting Rule 3 of 1981 rules, held as follows. Then it is also contended that by taking a plea that the petitioners are not coming within the definition of direct payment system, the state government cannot deprive the petitioners to get the benefit of pension in terms of 81 rules, as pension is not a bounty and the action of the state is also discriminatory and not sustainable.
We are not concerned.
Yes. So here, my lord, so far as Patra Sorang case is concerned,
Where is the comment made on that Patra in this judgment?
my lord,
Building that section because of introduction of 7C.
yes,
The law declared by Justice Hansaria stands liquidated.
yes. That has not been directly said.
It's not there.
That has not been directly said.
Referring to that, there is no discussion at all.
There is only reference has been made.
But where is the discussion?
A
Absolutely.
discussion that, well, so far as
Now let us read 7C.
7C, your lordship, my lord, may kindly come to section 7C. This was incorporated by way of amendment in 1994.
93.
94. Sir, that is a mistake. 94.
The book you.
94.
Yeah,
Again, 94.
Anyway, subsequent to judgment.
Subsequent to judgment.
Judgment is of June 18.
Yes.
June, yes.
This came into force on
7C.
7C.
7C came into effect with effect from 94.
Substituted by Odisha Act of number 14 of 1993.
That is a mistake. That is 94. Well, your lordship may kindly call for the gazette. Your lordships will get the exact date.
Let us read the section now.
7C.
By way of substitution.
Yes.
Which with effect from which date it is done is
Well,
developed because it is substitution.
It is
So will be retrospective.
Well, its substitution, it was incorporated in 1994. Well, in the footnote, there is a mistake that is not 14 of 93, that is 94.
Act number 14 of 94.
94. Sorry, 13 of 94. 13 of 94.
Gadget number is
Gadget number is
7714794. Although it is not mentioned here, but it is in the Gazette.
Gazette it is available.
Gazette number is 77
available. That is admitted.
What does it say?
But section 7C, granting it. The state 7C1, the state government shall, within the limit of its economic capacity, set apart a sum of money annually for being given as granted to private educational institution in the state. Then subsection 2, no order according permission or approval or recognition under this act, whether prior to or after the commencement of the Odisha Education Act 94, shall entitle any private educational institution to receive granting it.
1 second. What is that Education Amendment Act 1994?
Well, that
act itself.
Yes, this act.
This amendment itself.
Yes.
Therefore, it cannot be 93.
Yes, it cannot be 93. My lord, then your lordship kindly see subsection 3. Save as otherwise provided, no private educational institution which has not been recognized by the state government under this act shall be entitled to receive any aid from the state government. Then 4 is important. Notwithstanding anything contained in any law, rule, executive order, or any
judgment also.
Yes, decree or order of any court, no grantinate shall be paid and no payment towards salary cost or any other expense shall be made to any private educational institution or for any post or to any person employed in such institution after the commencement of the Orissa Education Amendment Act 94, except in accordance with an order or rule made under this act. Grantinate where admissible under the said order or said rule or order, as the case may be, shall be payable from such date as may be specified in that rule or order, or from such date as may be determined by the state government. Then you will kindly see section 7C7, which is most important, how the payment is to be made. My lord, your lordship may kindly come to the next page, 138.
A governing body.
A governing body or managing committee desirous of availing the facility of grantinate shall make an application for the purpose within such period and shall furnish such information and documents including audited statement of accounts of the institution as may be prescribed. It shall furnish with the application, this is important, an undertaking to the effect that grantinate sanctioned for the purpose or meeting part or whole of the salary cost shall be disbursed directly to the employees concerned.
So direct payment system is enacted in the law itself. So therefore, this judgment now pays.
Yes.
What do you say? Your section itself says. This
Your Excellency, once I will read once again. 7. A governing body or managing committee desirous of availing the facility of granting aid shall make an application to the purpose within such and shall furnish such information and documents including audited statement of accounts of the institution as may be prescribed. It shall furnish with the application and undertaking to the effect that managing committee of the governing body will furnish an undertaking to the effect that the grant is made sanctioned for the purpose or meeting part of or whole of salary cost shall be disbursed directly to the employees concerned and to refund any excess inadmissible payment that may have been made.
Correct.
So
your case is not that. This is not covered under this one. You have not stated in your objection statement that the body, the institution in question has not submitted any such application. On the other hand, there are some orders from your department which says it should be dispersed directly to the employee. Maybe in the light of this 7C7.
Yes.
Otherwise, they would not have said that. In other words, the grant is not to the institution. The institution is only an instrumentality or an agency. It takes the money from the state purse Institution is more like a big postman who will carry the money order to the address. That way the section is enacted. Maybe because the institutions were misusing the funds given, etc. That to ensure that the teachers will have assured salary from the government in an aided institution, this provision is enacted. Otherwise, there was no reason to enact this provision at all. Maybe that some institutions were playing mischief, some, not all, that they will retain that grant and they will not make payment to the concerned employees at all. And they may get a signature saying that, yes, we have received entire money. To overcome that, now the central government has that. The amount is directly credited to the account of the farmers.
DBT.
So that there will be no middleman, no pilferage. That way, this section is enacted. These sections are enacted with the rich experience of the government, with the people, how institutions run, what they do, how to protect the interest of the employees. All that wisdom enters the making of law. But you have not taken the contention, except that you are citing this 1993 June judgment. That pales into insignificance because in 1994 amendment, this is not 93 amendment, 94 amendment, because Act itself is of 1990 Amendment Act. As your brother pointed out, yes, the date, it must be like that only. It cannot be anything else. Anyway, that is one aspect of the matter. We'll discuss that's your contention. I have to meet it. I will.
Then your Lordship may kindly, for next 8, page 33 of the picture.
Annexure
Page 33.
The 4th June 2014 notification.
Yes, that also I have mentioned in my synopsis comparison. Sub-rule 2 of Rule 1. They shall apply to the lecturers, junior lecturers of non-government aided colleges receiving grant in aid in shape of full salary cost.
Yes.
What I have stated before your Lordship, that all these years, right from 2010, first time his appointment was approved in the on 17 to 2010, and till 23, till as of now, he is getting grant in it, not full cost. It's not at par with the government employees. That is 74 rule line I have placed before the Lord. Then,
kindly repeat.
Yes.
Grant in aid in the shape of full salary cost means what?
That is that your Lordship.
Entire salary
Yes.
of all the staff is reimbursed by the government. Yes. Then that rule is satisfied.
No. Then the person now here is the petitioner claims for getting the lecturer and A and reader post. In this case, my lord, full salary cost means that must be at par with the government employees or employees in the education.
Where is it stated?
Yes, your Lordship can see.
You are manhandling the section. If section wanted it,
Rule line. Rule line.
They have said that. Rule line.
Yes, rule 9 of 74 rule. Page 982, that I pressed just to paper. 982. Yes.
That was dealt with in that Patra.
I have taken it over to you. I thought running comment can go to. You are a senior man and you are giant in education matter.
Not a giant.
And then you are diverting them.
Yes.
Drawing of pay and allowance by employees of aided institutions. Every education institution shall draw the same pay, DNS allowance and subsistence allowance in case of suspension as is admissible to counterpart in the government educational institution under the relevant rules applicable to him and shall ordinarily
paid in the month following the month to which the claim relates directly by government or by any official or by any agency authorized by the government. That management is also can be termed as agency because my money was flowed to management and management was distributed. Yeah. So
One second. In other words, he cannot claim in excess of what is being paid to the employees in the government school. What is that you are saying by reading this section? Rule.
that is salary full cost means it should have par with the government policy. That much I would say. And now he is getting block grant. Not that par with the government policy. He has got the scale 9,300 to 34,000. That is my learned friend has shown. And also this placement rule also says 9,300 to 34,000. Rule 3 of applicability.
Yeah.
Rule 3
That's it.
Rule 2 of which problem?
Rule 1. That is page 33, Annex 8.
Apply to the junior non-government aided bodies in the shape of full salary costs.
And this says that before commencement of these rules, so he must have received 9,300, 8,000.
But he was getting even before that.
Only scale and grade pay. Our contention is not getting full salary cost. That is, this whole argument is before your lordship.
Where have you taken up that contention in your WS, in your counter?
Yes.
The institution is not getting, because the institution is enlisted in a schedule to the particular rule itself. 2009 rules, they have enlisted that institution. Kindly see that page, your friend has shown that.
Yes. 399.
399.
Your Lordship may kindly come to page
Annexer A.
page 410. 220. Puri Gop Junior College, Puri district, Gop Junior College, Gop. It is an old college getting full grant.
Kindly see that the heading, kindly see that Annexer A heading at page 403.
List of 255 non-government aided.
Annexer A is referable to which provision?
Alert. Annexer A
Is referable to
this is to the grantinate order of 2004.
which provision?
Provision, my lord, paragraph after completion of paragraph 10, it has been there. My lord, it is there. Sorry, rule 3.
Rule 3.
Rule 3A.
Eligible education is
Rule 3
of teaching and non-teaching.
Rule 3 small a. 255 non-government, page 400. 255 non-government aided junior colleges receiving full grant rate prior to commencement of the Orissa Education Amendment Act 94 as at Annexer A.
Is it a degree? It must be A, the 255 non-government aided
Junior colleges receiving full grant rate prior to
commencement of Orissa Education Amendment Act at Annexer A. They are getting full grant, even according to rule position. You have enlisted all the institutions in the state,
Aided institutions.
aided institutions in the state, and you have enlisted them in Annexure A. And name of his institution wherein he is working figures at item number 220 in the annexure itself. This is list of the institutions who have been getting full grant in aid. I appreciate the trouble you are taking is one thing, but the legal position, you have made a provision. You have not left any discretion to anybody in deciding whether an institution is getting entire full aid or not. It should be beyond the pale of doubt, beyond the pale of dispute. You have enlisted, saying that all these institutions are fully granted. But others need not wait. This matter will take some time. It's because we have to lay down the law in this respect so that what is the clear-cut position? I do not know what I am going to do. Perhaps I will reserve this judgment.
Yes.
After hearing you, then I will pass that.
I'll place paragraph 9 to my counter.
9 of counter.
Yes. Internal page 5. Before that, I start from my paragraph 7.
Yeah.
May I please?
Yes.
Paragraph 7. That as per Odisha Gazette notification number so Odisha aided college, aided junior college and aided higher secondary schools grant in aid amendment order 2013 by para 2 it is stated that in Odisha aided college, aided junior college and aided higher secondary schools grant in aid order 2008 para 16(1) of order shall be substituted as follows.
Where, 1 second. Where are you reading?
Paragraph 7 of my counter, internal page 3.
Yes. Appointed during
substituted as follows. The teaching and non-teaching employee of the non-government educational institution under paragraph 9 of GI Order 2008 who have joined in their post on or before.
It is not applicable to us.
That's me. Yes. Many things you have said which is not applicable. You have also relied Hemanta Chaudhary that is under substitution. You know that, but you placed before Lordship. So many things you have.
Yes, sir.
The teaching and non-teaching employee of the non-government educational institution under program 9 of GI Order 2008 who are joined in their post on or before the 1st June 1998 in educationally advanced district and on or before the 1st June 2000 in educationally backward districts and women's educational institution established which recognition and affiliation covered under grant in aid order 2008 shall be paid grant in aid in shape of block grant in the following manner. The eligible employee of the colleges shall be paid 60% of pay at the initial rate plus grade pay in the revised scale of pay ORSP rules 2008. The eligible employees on completion of 8 years from the date of sanction of block grant shall be paid 75% of pay at the initial rate plus grade pay in the revised scale of pay ORSP rules 2008. The eligible employees on completion of 11 years from the date of sanction of block grant shall be paid 100% of the pay at the initial rate plus grade pay in the revised scale of pay ORSP rules 2008. That as per Odisha Gazette notification number so the Odisha aided colleges and aided junior colleges and aided higher secondary schools grant in order 2017 by para 2 it is stated as follows. Subject to the provisions of this order, it shall apply to the employees who are governed under the provisions of the Odisha non-government colleges, junior colleges and higher secondary schools granting aid order 2008, the Odisha non-government Upashastri and Shastri colleges granting aid order 2009 and Odisha non-government aided colleges, aided junior colleges and aided higher secondary schools granting order 2009. Further, as per the amendment order of 2014, the teaching and non-teaching employees of the aided educational institution approved under GIA order 2009 shall be paid granting aid in the following manner: initial pay plus grade pay with 5 increments in the revised scale of pay of ORSP rules 2008. Further, as per the provisions of notification by the SRO number so-and-so, introducing granting aid order 2017, which effect from 1/1/2018, classified that the employees covered under the provisions of granting order 2009 will be entitled to get initial pay plus grade pay as applicable to such employees as per ORSP rules 2008 and DNS allowance at the rate of 136% and also allowing 5 increments in the scale of pay as applicable to the post under the provisions of ORSP rules 2008. Accordingly, the petitioner has received the benefits under the aforesaid notification of government and also received such benefits without any objection. It is further to mention that the revised pay as made applicable to the petitioner as well as the employees are non-government aided colleges in the state as per GIA Amendment Order 2014 or 2017 as is in the form of block grant and not on the direct payment scheme. It is humbly submitted that the Odisha non-government aided college lecturers placement rule 2014 was promulgated by the Higher Education Department notification number 12215HE dated 4th June 2014, which is effective from 1/1/2014. These rules are applicable to the lecturers, junior lecturers of non-government aided colleges receiving grant in aid in the shape of full salary cost. The provisions contained under Rule 1, 2, Section 2 and 3 of the said rule speaks that they shall apply to the lecturers, junior lecturers of non-government aided colleges receiving grant in aid in the shape of full salary cost. Such benefits shall come into force with effect from 1/1/14. Similarly, Rule 3 of the said rule 2014 speaks of applicability of the rule which specifies that these rules shall apply to the junior lecturers in non-government aided colleges who are in the pay scale of 9,300 to 34,800 with grade pay of rupees 4,600 under ORSP rules 2008 before commencement of these rules. In other words, it can safely be made clear that those lecturers, junior lecturers who are under direct payment system in the pay scale of rupees 9,300 to 34,800 with grade pay of rupees 4,600 as per ORSP rules 2008 before commencement of the placement rules shall be eligible for the benefit under the said rules. Since that petitioner should go through by virtue of notification of government dated 22/2/2013 and other subsequent notification has been provided with the said pay scale, but genesis of the service is approved under block grant scheme.
Let us see. Heard reserved.
And only one sentence
Only
I will
one clarification.
for your lordship that in the event there are so many, the floodgate will open.
What to do? If water comes that way, floodgates have to be opened in any day.
That also the economic condition of the state has to be right. That is.
Only one clarification. My learned friend has referred to 2008 grant in aid order that is not applicable to the petitioner because I received grant in aid as per the grant in aid order of 2009.
My lord.
with retrospective effect from 1993.
Yes, moment. My lord, my approved date of joining is 93. And another clarificatory order was issued by the state government. I have given in my written note at page 22 regarding implementation of that placement rules 2014. You lordship may kindly see that. Because if I will not raise that notification, my lord, I will be failing in my duty. Subject, clarification regarding interpretation of Odisha non-government aided colleges lecturers placement rules 2014. In inviting a reference, you lordship may skip over.
Which
Page 22
of today's
written note.
what is this?
Well, it's lecturers who have been retired or expired before 31, that is not applicable. Then put 2. The lecturers who are eligible for the post of lecturer, group A and reader state scale prior to 1/1/2014, they can get the benefit notionally from the date of eligibility without any financial benefit. Their pay will be fixed notionally from the date of eligibility up to 1/1/2014, and after 1/1/2014 they will get the financial benefit, this much. And 2008 granted order is not applicable to me. 2009 order is applicable where the name of my college is there. And I fulfill.
Service has been approved under 2009.
Service has been approved under 2009. Your lordship may kindly see, again, I will pardon your lordships by showing that approval order, Annexure 3 at page 17. 2009, not in terms of 2008. And those grounds have not been taken in the impugned order. Only ground is common cadre and not under the direct payment system.
But
in the MS Gill case,
very effectively he argued
yes,
that nobody can dispute.
And MS Gill case, they cannot go beyond the impugned order.
But he made his best effort. Very appreciably,
yes.
He made his submissions.
Yes.
I may be pardon to Nelson Miller. Item number 67.
All will come in a distribution way.
Item 70, I from